Thank you very much for all attending this morning. We've had great interest in this selling, merging and passing on a legal practice. This is the second of these events that we've had for practitioners. We have a number of people that are watching online. I've even been told that there are practices that are watching it together. They've grouped together solicitors and they're watching it all together this morning, so hello. So without further ado, we're going to get into it. First of all, we have Keith O'Malley. Keith O'Malley is our Head of Support Services, and Keith is going to do a general introduction, followed by retirement and retirement planning options. Then Simon. Simon is our Legal Executives Regulation Executive. He will talk about the change in ownership regulation requirements. Followed then by Aidan Leonard. Aidan Leonard is the Claims Director, DWF Claims. He's going to talk about insurance implications of selling and passing on. That'll discuss the Special Purpose Fund. We have Mary Jackson. Mary's over here from the UK for Law Care, and she's going to speak about mental well-being and peer support. Quick break then for tea and coffee. Then we're going to have Barry McCarthy. Barry McCarthy is the tax consultant with Hayden Accountants, and he will speak about tax implications of selling and passing on. Followed then by James Cahill, Principal with Cahill & Cahill. He's going to speak about options for practice organisation. And then finally, we're going to have David Rowe, Director, Outsourced Finance, and he's going to speak about options for selling, merging, passing on, a more general overview.
Keith O'Malley is my name. I'm with Support Services. That's career support and also practice support. And I'm going to talk today about options facing solicitors as they approach retirement and as they organise retirement planning for themselves and their families. You've essentially got three options if you want to get out of your practice. Number one, you can sell. Number two, you can pass it on to another. And number three, you can close it. Or die. I think I was going to, yes, that's the ultimate get out, really, isn't it? The quickest and most immediate is I must put that on my next slide. But okay, it's staying alive and getting out of practice. You've got three options. Well, number one is to sell, number two is to pass it on to another solicitor, and number three is to close it. Another option you've got is you can wind down, and in a lot of ways this is the default option for a lot of solicitors, and we'll talk through. It is a bit of a two-way street, isn't it? Sometimes people wind down, but then eventually they decide to do one of the other three things, either sell, pass it on, or close it. But I think a lot of solicitors, kind of float between this area of, I get out, if I had the option or if circumstances were right. But for the moment, I'm just going to wind down practice and try and get it to fit the kind of way I want to work and live at the moment. The other option, though, is to wind up, and there's quite a good argument for that, and we'll talk about that in due course. But we're going to start by talking about getting out and then move on to winding down. So if you want to get out through selling, the questions that people get, that we get all the time are, can I do it? If I do it, how much is my practice worth? What exactly will I be selling? And how and when, how should I prepare and when should I start? So just quite simply, can you sell? Yes, you can. And you can sell any combination, of your practice. You can sell your practice and the premises it's in, if that's the case. You can sell just your files. You can sell the goodwill of the business and work in progress, but not sell maybe the premises and even the debtor. So you can sell any combination, and people are doing that. How much is it worth? Well, unfortunately, that's like that, a question, how long is a piece of string? Things are really, really up in the air in terms of how much a practice is worth at the moment. As everybody knows, the market for legal practices completely collapsed in 2008, 2009. Banks and insurance companies quite simply wouldn't let solicitors take on other practices. And since then, there's been a recovery, but it's been a gradual recovery. But we haven't got back to the situation where legal practices were on the same footing as accountancy practices. If you go to buy if an accountant goes to buy an accountancy practice at the moment, they're still buying it based on turnover, maybe 1 year's turnover, or some variable, either but based on what the annual turnover is. That's not the case with accountancy firms or with legal firms at the moment. By and large, turnover is not being used, nor is profitability. Things are different. And the market in practices has recovered, unfortunately, I'm sorry, but particularly within Dublin. It's that age-old thing. A lot of things have recovered faster and quicker in Dublin than the rest of the country, and that is certainly true with regard to what a practice is worth. The traditional way of valuing a practice, like any business really, tended to be, it could be done on turnover, it could be done on profitability, it could be done on net assets. So you might look at, you give a value for work in progress, you give a value for furniture, stock, debtors, and goodwill, and you net that off against whatever liabilities exist, and you say, well, the practice is worth 150,000 or whatever. That's used to a point, but not an awful lot. The big one, of course, is the last one, which is realizable value, and that simply means your practice is worth what somebody will pay for it. So if you want to sell your practice, and particularly if you want to sell it now, in the next 12 months or something else like that, what dictates what your practice is worth is what somebody else is prepared to pay for it. So, and that's why people tend to do that bit better in Dublin, because if you've got a practice in Donnybrook or whatever, it's likely that there'll be a number of solicitors who will be interested in it, and when you have a number of buyers in any potential transaction, it's going to work out much better than when you're struggling to find one purchaser or one prospective purchaser. So how much your practice is worth really comes down, and David, our last speaker, David Rowe, is going to talk more about this, but it comes down to the kind of interest you can generate, the number of people who maybe might want to compete and drive up the price. But essentially, though, it is important. There are some fundamentals. There are a number of things that make a practice more valuable. The first is lucrative work, and particularly lucrative repeat work. So if you're doing a lot of work for the Sisters of Charity and you've done it year in, year out, and it's conveyancing work or rectification of title work, and the likelihood is your firm is going to be doing it for the next 5 or 10 years, then that impacts very positively on your price, because you're doing work that you're not, isn't particularly price sensitive. You can charge a reasonable and decent amount for it, and it's likely to continue over a number of years. The second thing is non-personal work. If you're getting a lot of work from your brother-in-law or aunt or something else like that, who's in a very senior position, maybe within an insurance company, there's the question, will that work continue if you depart from the business? The third is automated work. So if you've got work that you're not really terribly involved, that the work comes in, the work is somehow done, ideally by a machine, and you get paid for it at the far end, well, that's valuable work. So people who are purchasing businesses would be particularly sensitive and interested in that kind of work. So in a lot of ways, I guess, debt collection is that classic thing. You've got, you're working with a financial institution or whatever, they're giving you a lot of work. You send out, it's an automated process where, a warning letter goes out and a second warning letter goes out and then proceedings are issued or something else like that. That is valuable because it can be done without, it can be automated and done without, at a relatively low cost. And the fourth one is, what else affects the price of work? It'll come to me in due course, but there is a fourth one, and it comes up, it features on a later slide. So, those kind of issues impact on what your practice is worth, the kind of, good quality work, ideally repeat work, non-personal work, automated work, and I still forget what that last one is. What will I sell? The best advice in terms of what you should sell is as little as possible. And what I mean by that is, if you've got a firm and it's in a premises that you own, if you go out to sell that firm with the premises, all lock, stock and barrel, there's all sorts of problems in terms of what you think the premises, for example, is worth and everything else like that. Better off to separate it, sell your business, as a going concern if you can. And if you wanted the business to stay on within the premises, offer some kind of a letting agreement. So you're saying, I'm selling this business. There's also the option that you can let the premises at this rate, and you might give them a particularly attractive rate to get them in. Second thing that it's a good idea to not sell on are debtors, because there's an awful lot of things you have to kind of squabble over in terms of valuations. And, one, debtors, it kind of comes down to, well, what's the point? Because if you think your debtors are worth 100,000, they think they're worth 60,000. You can spend a lot of wasted time. Whereas if you think they're worth 100,000, you say, whatever agreement we'll do it on the basis that I take these debtors and I collect them over the next while. And that, of course, reduces the price and it can make a difference. Furniture, things like, you may spend a good deal on furniture and equipment in the firm. It doesn't tend to be worth an awful lot if you're selling. When you're selling a business, particularly within the market, and I think what David Rowe is likely to say is your business has the value of your business comes down to two things: work in progress and goodwill. And work in progress now tends to be, quite often, the way an agreement, a sale agreement works, is it's paid for as it comes in over a period of time. So it's deferred payment on work in progress. And goodwill, yes, it's worth money. It's not worth a huge amount of money, that should be paid for up front. That makes sense that the person would pay for that up front. But quite often, people are taking over practices at the moment for a relatively upfront payment, a relatively small upfront payment, 20,000, 30,000 for goodwill, and then they're paying for other things, as they come in, work in progress, and possibly debtors if debtors are sold. The problem, and there's an accountant coming in, and he's from Hayden, and he's going to talk about this. But it's a really important thing for a person selling a practice, is there can be quite significant tax implications depending on the way you structure a sale. So if you agree to take your work in progress over a period of years as it comes in there's a strong likelihood that that money will be assessed as income as opposed to a capital gain. The difference between paying, settling your tax liability on income as opposed to a capital gain can be significant. So if you've got a good pension and you're up towards the top rate of tax, if you're paying income tax on your work in progress that you get in time, that's you're at quite a disadvantage compared to if you had got paid for it up front and it was seen as a capital gain, something that you had gained over a period of maybe 30 years building up your business. And for that you would be subject to capital gains, and as I said, the accountant will talk through more details on that. How and when should you prepare to sell a practice? As soon as possible. The sooner when certainly. Sorry, I'm answering the second question there first. As soon as you decide, and probably even before you decide that I need to start thinking about winding out of my business, you should be doing things to move your business into a situation where it is as it is as valuable as it possibly can be. You wouldn't, if you're selling your house over a year or two beforehand, you would tend to, give it a paint up and patch up all the kind of things that might impact negatively on it. And it's the same within your business. Your business is, for an awful lot of solicitors, it can be the largest thing of value that you may have, and you want to get maximum value out of it. And a lot of that comes down to preparation, and we'll talk about that in due course. So selling supports, what have you got? You have consultants. Unfortunately in Ireland there are not an awful lot of people involved in this end of the business. David Rowe really is the only person at the moment who has much involvement in buying and selling practices. It is important that you can get some kind of evaluation on your business, but that's difficult, as I said, because that is terribly dependent on the availability of buyers. So, but if you can meet with David Rowe or somebody else, and the other people, of course, are accountants. Accountants tend to be generally good at advising on the sale of a business, but some of them, like Hayden accountants, are particularly good at it. They do a lot of it. So they can help you, they can talk through things like tax implications, and they can give you some idea of what kind of valuation you should expect for your business. There is a facility on the Law Society website called Buy, Sell, Merge, and a lot of people don't fully understand what it's about, but it's a really interesting facility for somebody who wants to kind of explore either purchasing a business or selling a business. And the reason it's good is it's a forum. So, if you have some interest in either buying or selling a business or merging a business, you can put up an ad. But the interesting thing about it is whoever puts up the ad is anonymous. You cannot be identified. So you put up an ad, and people are a little bit wary because you're asked your email address and that. But that doesn't go anywhere. If anyone is interested they see your ad and they're interested in getting more detail, they reply to the system, and their email is sent on to you. But if it's somebody who you don't particularly get on with, you don't have to reply to them, and they will never know who you are. So nobody, ourselves in support services, we don't know who advertisers are. So Buy, Sell, Merge is a very nice kind of discreet way of just getting some kind of idea about the interest in whatever you're proposing. The practice advisory service is another option. Again, we're back to David Rowe. David Rowe provides the practice advisory service for the Law Society, and it's done on a subsidised basis. I don't know what the charge is. It's 250 euros or something else like that, but the Law Society pay pretty much the same as well for him. He comes in, he looks at your practice, and he sits down with you, and he talks through what your aspirations are, whatever you're seeking to do, and how you might most effectively do that. So, if you were to call him in and say, I'm thinking of selling a practice, he'll look at it, say this is what you've got going for you. This is, a problem area or whatever. So the practice advisory service is a good support for people who are looking at buy, sell, selling, merging, or somehow passing on the business. We're talking here about selling supports. To get out through passing on the business, and I'm not sure if this is the correct term, but it's the one I use. And what we're talking about here is where a solicitor in practice identifies somebody who they would like to take over the practice in due course, and they come to an agreement with them. So it tends to be done on a pre-agreed and scheduled arrangement. So you say to somebody, would you be interested in either becoming a partner within my firm or in taking over my firm, and I am going to depart in 12 months' time or in 24 months' time, or I want a different kind of role. I want to be a consultant, I want to be able to, when people phone me, I want to be able to come in here, meet them, talk them through and say, yes, well, that's fine, but John's going to, look after this now on a day-to-day basis. So, you act as almost as an ambassador for the firm and a client manager. So there's any sorts of arrangements possible within this. The thing that a lot of solicitors are finding difficult is to select the right person. Dare we call them the younger generation. Solicitors in their 20s and 30s don't seem to be as interested in enterprise as our generation was. So a lot of solicitors who are coming up towards retirement are turning around to junior solicitors that they have and saying, how about taking all the practice? And the person says, no, not for me, There's two reasons for this. Number one is it would appear that generation is not as risk interested as our generation is. But there's also another problem. James Cowell said this at a meeting I was at, and I thought it was interesting. He said there's an awful lot of partners, there's an awful lot of practitioners are turning around to their staff and saying, you have no idea what it's like to try and keep this practice together or whatever, I'm paying you more than I'm earning myself. And then they're turning around and saying to them, by the way, would you be interested in buying practice? So, you can't have your cake and eat it, unfortunately. So there is this issue about the story you tell. But it is challenging to find a solicitor who, number one, is interested in taking over your practice and is compatible, with you, and you can work well together, and you can get through that transition. And the next issue is, when do you do it? Do you start doing this in your 40s, or do you, do this a year before you're thinking about doing it at age 63 or 4? It seems to work best when there's long-term arrangements and when you're telling people from an early time, my plan with regard to the practices is this. And it is a wonderful situation, isn't it? If you build up a practice and you've worked in it 30 years, we're all, we all have a level of vanity. We would all like that practice to continue on. We would all like to, walk down the road in our 70s and our 80s and look at Jane O'Connor, solicitor, still on a brass plate. And you can achieve that by passing on your firm. And it makes a huge amount of sense to the people that are passing it on. And we in support services are going out and we're saying to young people, you have no idea the great value you can get in buying a practice. So we're very much promoting the whole concept of buying practices among younger solicitors. And the main reason we're doing it is there's a huge opportunity. You are caught, people who have practices, who have built up a practice over time, as far as you can only sell it on to a solicitor. So we in support services are encouraging younger solicitors to think about it. When to agree matters. sometimes people go out and they hire on the basis that I want somebody who is going to come into this firm and is going to take it over under these broad terms. And other times you get somebody in, maybe somebody who did their training with you, and over time, you come to that kind of agreement. In that first option, where you bring somebody in with this a specific intention to pass the firm on to them, one issue can be this thing about remuneration in the meantime. If you've got a practice that is bringing in, 100,000 and you're making 40,000 out of it, and you bring in a young solicitor to take over your practice, it can be difficult to fund it, to pay for it, because they're going to want 40, 50,000 or whatever pay. So, you can find yourself quite simply working for nothing or for next to nothing, So you brought somebody in, they're taking the lion's share of what is essentially profit, and you're working for 2, maybe 3 years for little or nothing, just simply to transition it, and that is a challenge within this whole concept of passing on. And trust is a big issue, particularly, as we said, when more and more parts of a selling or passing on agreement tend to be about deferred payment, where you're saying to somebody, litigation files that are underway, let's agree the following percentage and you're going to pay me that as it comes in. There's a huge amount of trust on your part, and there's a huge amount of trust also on the person who is purchasing from you or who's taking over the firm from you. Passing on supports colleagues with experience. So if somebody else has done it, and I guess what we should do in support services, is get some stories from people, and if we could, have some where a booklet of stories about people who have passed on their practices and how that has gone, and the details. I think that would be helpful, and that's something that we'll look at. The buy-sell merge facility is a good way of identifying people. It's great if you can get a facilitator in place, and that could be some consultant like David, or there's a range of other people. Obviously, your accountant can do it as well. But there is this issue all the time, about value. What is the firm worth? And the kind of person who works best in this kind of arrangement, where you're passing on to an employee or prospective employee, is an honest broker type person, somebody who stands between both parties, as opposed to you having a representative and they having a representative. Support services at the moment has some templates being drawn up, so a template for passing on and that will be ready, I understand it, certainly before the end of the year. They're being drawn up by a professional firm, and they will be in place and made available to everybody. Thing. The Dublin, as I understand it at the moment, Dublin Bar Association have a template, a partnership template, but we will have a partnership template and also one for passing on of practice. And as I said, they'll be ready before the end of the year. Getting out, if you decide to get out through closing your practice, there's a range of ways of doing that. You can sell your files, you can distribute them on to others. I don't need to go into too much detail on this because Simon is going to talk about this. I think it is important though to say that when you finish, and you cannot, a week or two later, if somebody phones you and say, what about that form that didn't go into the registration office or whatever, you can't do it. The day you finish, if you're particularly, if your professional indemnity insurance ends, it's against the law to do any further work, and you also expose yourself to personal liability. So, dangerous territory. Termination is absolute. And myself and Simon were just talking about an issue that happens around this, and people quite often a long time in, well in advance, decide I'm going to close my practice. PI insurance terminates at the end of November. I'll close my practice at the end of November. I would suggest that's not a great idea. Much better off to plan to close the practice halfway through the year, in June or something else like that, because invariably it takes longer. Simon was saying he gets calls, in the last week of November, somebody saying, hi, I'm thinking of closing my practice on Friday. It's a recipe for disaster. Plan, if you're going to close a practice, understand that it will take you a good deal longer than you expect. And really, it's a good idea to start planning early, and also to plan for a halfway period through the year or something else like that, so that you don't have this, or of course the worst situation is you end up then taking up professional indemnity insurance because you still have 3 months more work to do. Plan and give yourself time on that front. Practice closure supports. Colleagues, people who have done it, of course, are a huge source of information, and I think you'll hear from people through Bar Association. You can link up with people who have done it before and where they stand. And obviously, the registration section of the Law Society Regulation Department, they have very much a vested interest in this, that practices are closed responsibly. And of course it impacts on PI insurance and on run-off cover, but we're going to talk about that as the morning progresses. Wind down, as I mentioned earlier, and people nodded their heads, wind down tends to be the default option. You might think, yes, it would be great to close my practice or pass it on to somebody else, but if somebody doesn't come along, you'll tend to, the nature of professional firm is, you've got responsibilities, or you feel you have responsibilities towards clients and sometimes the staff, and you just keep things going on. The risk on that is, as your business winds down, particularly if you don't do anything about overheads, and staff overheads are the big one here, practitioners can find themselves over time working for less and less money, and sometimes for no money. So you're running a practice to quite simply pay for your staff and convenience your clients. And you have to be fair to yourself. And we would have people contact us. They're in their 70s, late 70s, or whatever, and it's gone on too long, and not only are they not getting sometimes anything out of the practice, but the practice is actually costing them money on an ongoing basis. So if you wind down your firm, have a plan in terms of that you're going to reduce your costs at the same time. Do not allow yourself to get into that situation. Another thing is, if you're going to wind down your practice, by and large, it tends to be a good idea to focus on one thing. When you're setting up, and sometimes as you continue to operate, whatever comes in the door, you'll do it. But if you want to work shorter hours and you want to get better value out of your time and work, it's probably a good idea to say no to work and to focus on what you're better at. So you decide what you want to do. I'm only going to do conveyancing, I'm only going to do whatever, and you walk away from other stuff. Collaboration, within those kind of circumstances, collaboration works well, and I suspect this is something that James Cahill will talk about, but because I know he's keen on this whole idea about solicitors collaborating together, and why should I be doing conveyancing and doing lots of other things if all I want to do is conveyancing? Why don't I do that work, focus on that, and by collaborating with other practitioners, colleagues, everybody within a particular locality, everybody can do better. Wind up. Why would you wind up? Well, if you're thinking about, I want to get out of this business, but I want to get out and do as well as possible out of it as possible. So within that situation, and particularly for somebody who's more planning than immediately seeking to get out of business, it can make sense to actually wind up your business. And what we're talking about there is getting more business in and maybe increasing business and possibly even increasing staff. And it tends to come down to these two questions. What is the most lucrative work that a solicitor can do, and what's the most effective way for a solicitor to substantially increase earnings? The answer to the first question is repeat work. The most lucrative work you can do is the same work you did yesterday. So if you've just been through a particularly complicated litigation case and somebody walks in the door and they're looking for exactly the same, happy days, and if in the afternoon somebody else comes in with the same work. So if you want to sell your practice and you want to maximize value, one way of doing that is to get as much lucrative work in as you can. And same work, repeat work is one way of doing that. And the second one is, what is the most effective way for a solicitor in practice to substantially increase earnings, is to not do it yourself. So if you have staff, either solicitors or legal executives, or even better still, machines doing particular things and doing lots of them, and you getting charged for them, you can do well. So you might look at, is there work that I can do that I don't have to physically do myself, that I can get it done in some kind of a more automated, hands-off way, and can I get a lot of that kind of work in advance of selling my practice? So, and this is the last point here. I was saying about things that affect practice valuation. That was the one I couldn't think about. Risk management. Has your practice got a good record in very few complaints and insignificant complaints and any kind of losses? So if you're winding up for your sale, anything that you can do to increase the amount of lucrative repeat work, non-personal business, and any kind of automated work will increase your value. And you say, well, hang on, I'm 63 years of age. I can't kind of, reinvent my whole practice. I'm doing something for... I'm running my business a certain way for the last 30 years. And yes, that is true. But sometimes, you can achieve a lot by doing a little. You try something and it works out well, and suddenly it opens up and it's 25, 30% of your business. So just be aware of opportunities. Take that thing, well, maybe, approach to looking at business opportunities. If you're winding up to pass on, what you're doing is you're leveraging what you have for something even greater. So you've got a practice or whatever, and you say, somebody else is going to take this over. But if there's some things I can do in the interim to make it into a bigger practice that might survive for the next 100 years, the next William Fry, I'd like to do that, and so that's going to be my project for the next few years. And an awful lot of passing on comes down to talent management. It's one thing being a good solicitor, but if you want to pass on your practice, where you're really going to have a greatest success is if you identify a really good person and then manage that transition and facilitate that person to reach their absolute potential. And ideally, if they're doing it in the name of your firm, it's got that legacy prospect that you do become the next William Fry, and you end up with a picture somewhere here in the Law Society on the wall. Other issues with regard to winding up. One option is to focus on what interests you. So, it's one thing saying, go out and get lots of lucrative work in or whatever, but that can leave a person pretty, uninterested. But if I said to you, you seem to be particularly interested in law about wind farms, and you seem to be, positioning yourself nicely, why don't you do more on that? So what tends to work in these circumstances is if you have a kind of a pet interest, just consider, is it possible that you could open up and make it into a more substantial part of your business? That tends to be the kind of situation that works best. And of course, how you do that is you seek to become the acknowledged expert. You write some articles, you go on local radio, and you start, developing a reputation for yourself. I hope he doesn't mind me saying, I think Richard Grogan has, I've seen in the last few years has filled that space. He was, as I remember, was a general practice solicitor. He's decided to very much focus on employment law and has very much marketed himself through social media in that as an employment law expert or whatever. So that's the kind of thing I'm talking about, where you get interested in something and you decide to go out and establish yourself and your firm within that space. And you can build a reputation on social media. But to do all of this, you have to a point, stop thinking like a solicitor and start thinking more like a marketing person. It's a marketing project as opposed to a legal one. And some solicitors don't particularly like that idea. I am a legal practitioner. I'm not going to, become a marketeer. But there is a practice value can be maximized if you start thinking a little bit more like a marketing person. I'm going to finish with this. This is an idea that a few different people have had, but there's an Irish-born management guru called Charles Handy, and he came up with this idea about the sigmoid curve. And really, it's the product life cycle. Everything in life seems to go up, have a period of ascendancy, then level out, and then fall. We all grow, mature, and decline. And what he says is, within businesses or within a career, it starts off, and you need to put kind of resources in a business to get it going. Practice takes time to take off, and then it takes off, and things go well, and it goes better and better, and it throws off more and more benefits. And then at a certain time it matures. Now it might mature over kind of wider place like that, but at a certain time it goes down, and this is what a practice tends to look like. But if you want to, this whole idea of winding up and making your business particularly more valuable, as I said, the Richard Grogan, we are now employment law specialists. At some point, what you do is you decide to do something else. We, are going to very much focus on employment law, and you do this, and it takes a while for it to take off, to establish, and then it takes off, and over time it throws off all sorts of benefits. But what Charles Handy says, the timing here is really important. What you need to do is start a new thing while your existing business or your existing enterprise is still, doing well and throwing off lots of benefits. That if you leave it here, this business is going down. You're not going to have the resources, in order to set up the other business. So he talks about this thing called Davy's Bar. He said one time he's driving through Wicklow, and they're looking for a particular church, I think it is, church, yeah. And they stop there's a farmer at the side of the road, and they ask for direction. And the guy says, we go on there, the thing. And he says, you come to a crossroads. And he said, there's a pub at the crossroads. It's called Davy's Bar. Well, he says, if you see Davy's Bar, you've gone too far, because the turn you were meant to take was a half a mile back on the right-hand side. So, they start off on their journey again, and he chuckles to this idea about, you have to go beyond the point to go back to where you should have turned, to know that you've gone too far. But what he says is it's so true with businesses as well. But if you've got a business and you want to do something more with it, do it before the first business starts declining. So don't wind down your business and then say, I'm going to do something else, because to do that, you end up without enough resources. that's me finished. Simon is going to speak next.
A very good morning. My name's Simon Traynor and I'm a practice regulation executive in the regulation department of the Society. And so I'll have a little look at the requirements for selling, merging, passing on, or a change of structure of a solicitor's practice. And all of these particular matters require at least one cessation will have to take place. And of course, you'll have taken care of all the matters that Keith has given you into account. And as Keith would say, do plan these things in advance. So it's probably better not to do it just off a whim. So if you're selling, merging, passing on in practice, or if there's any change of firm structure, and a change of firm structure would be where maybe one sole practitioner is being replaced by another, where a sole practitioner is turning into a partnership, or where a partnership is turning into a sole practitioner. You will need to execute a cessation. Now, so the basic cessation requirements are just up there. We're currently developing the application form, so we haven't quite got there yet to make it a bit more of a simplified process. But what we will require is that you notify the Law Society. We would recommend at least 14 days in advance, although you can do so longer. We'll need a home or correspondence address, and this can even be an email address or something like that, and purely on the basis that if there's a situation where a client has to contact you to ask you a query, that we can provide them some kind of an address to contact you. Client files, very important. We need to know where client files have gone. We need to know not specific client files. I don't need to know John's client file has gone to this solicitor's practice and Mary's has gone to that. But we need to know a sort of more general thing where the client files are, I've sent client files to Murphy solicitors, to Smith solicitors, and the Society will always take a note of that. And the reason we need to know something like that is you will write to clients when you're ceasing practice, and not all of those clients are going to respond. They're not all going to nominate a new solicitor. They might leave it in abeyance. And then maybe 2 years later, they ring up the Law Society and say, my former solicitor ceased practice and I don't know where my client file is. And we will always have a note of saying, well, this solicitor finished on the 30th of November 2018 and we know the client files went to this practice and that practice. So it's a very practical reason for clients. You will need to file a closing accountant's report within 2 months of the cessation, reflecting nil balances on the client account. And professional indemnity insurance is not a matter I'm actually going to speak about, but I will just let you know you will need to either have run-off cover in place or you will need to have a succeeding practice in place. Client files should be insured at all times. Aidan Leonard is going to speak more about run-off cover and succeeding practices, which takes some of the heat off me. So looking at notification to the Society, as I said earlier, cessation application is being developed, still in the development phase, but we'd ask to provide notification at least 14 days in advance. Now, sometimes solicitors give us months in advance, sometimes they want to know in January, we're finishing in November, and there's no problem with that, but do provide advance notice to the Society. Provide the identity of any practicing solicitor or solicitors to whom files have been transferred. That's both open and closed files, and we would require written confirmation from that solicitor that they've received those files. Now, those solicitors that files have been transferred to do not necessarily have to be succeeding practices. They may just have access to the files. So I would say, yeah, correspondence address, as said earlier. That could even be just an email address because the Society will not be a conduit for correspondence between former clients and former solicitors. So we need some kind of an address in order to contact you in the unlikely event that it is required. And confirmation of run-off cover, succeeding practice. The succeeding practice and the preceding practice should both have written confirmation of the position when they're going to be a succeeding practice and the practice that they're going to be succeeding to. So, advise clients as long in advance as you can is the best recommendation, that the firm is either ceasing, if it's merging, or if it's being sold. Client files, of course, belong to the client, not the solicitor, and that must always be borne in mind. So you should write to the client, give them an option to nominate a new firm, new solicitor of their choice, or to have the file returned to the client if the matter's finished, if that's appropriate in the circumstances. And if you're going into a situation where you're maybe merging with another firm, or the firm has been sold, and the client is happy for that new firm to act, you should request a fresh authorization from the client in order to do so. In the case of sale or transfer of a firm, so the society would like know, again in advance, plenty of time, the date on which the firm has been sold or transferred. Clarification whether all the files have gone to the new firm or maybe some of them have gone to other firms. Again, this would just be a note that the society would have in case former clients contact. If files have been distributed between various firms, please advise the society of that in advance and get those firms to contact the society to say, yes, this is the position. Confirmation that client money has been transferred and whether the new firm is a succeeding practice or not. Again, I'm not going to go too much into that because Aidan Leonard is going to detail about succeeding practices and run-off cover. The currency of the solicitor's profession, as we all know, is an undertaking. And it's very important that you take register of these, make sure any outstanding undertakings are noted and they're dealt with. In an ideal situation, all the undertakings would be discharged, but we all know that's not a practical situation and it's not going to happen in most cases. So ensure that the undertakings, and if you're the firm taking over a new practice, make sure you do your due diligence and note any undertakings that are outstanding. Closing accountants report. So closing accountants report has to be submitted to the society within 2 months of cessation. It must reflect nil balances on the client account. So the deadline for submission is 2 months, but if there's going to be any outstanding matters, you can notify the society, set out the reasons, and continue to submit annual reports until the client account can be closed and nil balance can be reflected on the client account. So the closing report at the end there, as you see, it's when the client account goes to zero, as per the bank statements. It's not necessarily the date of the cessation of the practice. Where there is a change of structure, it's a slightly different scenario. So the bank accounts are closed, new bank accounts are open for the practice. That's where there's a change of structure from a sole practitioner to a partnership, for example. Sometimes it's not always possible. So the closing report can be submitted with these 3 requirements: the letter from the firm's bankers confirming they're aware of the change of structure, a copy of a new bank mandate, and written confirmation from the reporting accountants that they know there's a change of structure in the practice. So if there's a purchasing firm, they should always provide notice to the society of the proposed merger, purchase, acquisition. If there's going to be a change of firm name, they have to comply with SI number 178 of 1996. So that would require, if your firm is called Smith, that's fine. Smith Law is fine. Smith Legal would be fine. But if you wanted to call yourself anything outside of second names of the partners, then you would have to make an application to the Regulation of Practice Committee. So if you wanted to call yourself Blackhall Law or Blue Sky Legal, you'd need to make an application to the Regulation of Practice Committee for approval for those names. If there's going to be any change of firm address or contact details, again, this would come under Section 81 of the Solicitors Act 1954, which requires a solicitor to detail to the registrar within 14 days any change of their place of business, and notify if there's a change of status in any solicitors joining the firm. So if any solicitors joining your firm are now becoming a partner or assistant solicitor, consultant, again, notify the society plenty of time in advance. And if you have any queries, there are all our general email address.
Morning, everybody. My name's Aidan Leonard, and I'm the Special Purpose Fund Manager, and I'm here to talk about the wonderful world of insurance and the exciting world of insurance, which is quite topical at the moment. What we hope to cover today, in some detail, as fast as I possibly can, is what is the Special Purpose Fund, who operates it, why it was introduced, the eligibility criteria to operate within the fund, touch on the succeeding practice, your obligations pre and post cessation for your insurance requirements, and how the cover is different to your current indemnity cover whilst in both the ROF or the ARP. We'll then touch on compliant and non-compliant firms and the obligations and the ramifications to fit into either of those categories. And then just at the end, just current trends associated with the Special Purpose Fund, the types of claims that might emanate from when your practice closes, things like that, just to give you an idea of what maybe you should be closing up or when you come to the end of it. So, what is the Special Purpose Fund? The Special Purpose Fund was introduced in 2011, and it's made up of two particular aspects. It's the run-off fund and the assigned risk pool. Now, historically, the assigned risk pool always operated. But in 2011, the Law Society, through participation with the insurance companies, decided that that model wasn't fit for purpose. Because essentially, you were only guaranteed 2 years run-off cover post-cessation. And in reality, that wasn't the purpose for which run-off cover was set up, i.e. the public protection argument. So what was set up was a special purpose fund, which again was divided into two aspects. One, the run-off fund, and two, the ARP. Now, the run-off fund provides cover, all run-off cover, and it's for firms who cease practice on 1 December 2011. You must meet the ROF eligibility criteria, and the indemnity period runs as per your current indemnity period. Secondly, the assigned risk pool. That currently operates for firms who just wish to participate, who cannot get cover in the open market. I suppose the assigned risk pool cover we'll touch on the basis of the cover that's in there, but essentially it runs on the same line. The indemnity period runs from 1 December to 30 November. And crucially, the Special Purpose Fund is funded by all the participating insurers in proportion to their market premium for any given year. Who operates it? We were appointed to operate on behalf of the Law Society on the 1st of December 2014. And I suppose the key aspect of this slide is as follows. The Law Society does not run or has no liability for the run-off fund. It's not to be confused with a compensation fund, which can happen on occasion through no fault of the public. And as SPF manager, we act as an agent for all the insurers for each of the indemnity periods. I suppose why was it introduced? I touched on it in the beginning. It was really brought in to assist firms intending to cease practice, and it was making retiring more affordable for solicitors and giving more comfort for solicitors who are retiring to their obligations when they cease practice, to give them the peace of mind in their retirement. It was there to improve public protection by virtue of the claims that emanated maybe post 3 years, 4 years, 5 years after a firm has ceased. It also was brought in to prevent abuse of the system, and we'll touch on the succeeding practice. And I suppose it was an incentive for solicitors ceasing practice to do so in an orderly manner. To get run-off cover, it's free, and all you have to do is comply with the obligations coming up to your retirement. Now, as I say, there's two aspects of it, so I'll kind of touch on both very quickly. And as you can see from the slide, there's ROF and ARP eligibility criteria. And essentially, for firms closing, a firm who has qualifying insurance with a participating insurer on the operate date of the regulations, or more crucially for this year or next year or whenever people decide to close their practice, holds qualifying insurer with a PI immediately prior to coming into the ROF. And a firm which there's no succeeding practice, and that's one area, again, I'll touch on in a little bit. ARP is more or less the same, except you do pay a premium to enter into the ARP. So if you decide for one more year you want to keep your practice open, you can't get cover on the open market, we're duty bound to provide you with that cover. However, it's subject to payment of a premium that's predetermined by the regulations. The succeeding practice rule. The intent of the run-off fund is to allow firms who cease practice come into the fund and who want to retire. That is the overarching feature of the run-off fund. It is not designed for firms who just feel that they can just take their liabilities, put it into the fund and continue it somewhere else. So we, as an entity, and on behalf and custodians on behalf of the Law Society and the PIs, have to investigate this particular aspect. And it's done fairly and objectively. I mean, what we try to do is look at why the firm is closing up, how they're closing up, and what they're doing. And these are the key 6 areas that we look at. And it's a collaborative approach with the firms that are closing down, who may not actually understand what the succeeding practice rule actually indicates. And as I say, there are 6 main aspects to which we look at. And it has to satisfy one or more of the following. It is held out as being a successor to the practice or part thereof, or whatever means this occurs. Half or more of the partners of the practice are identical to the partners of the ceased firm. It's conducted by a sole practitioner who is a sole practitioner conducting the preceding practice. It's conducted by a sole practitioner who is one of the principals conducting the ceased firm. Where the sole practitioner who conducted the ceased firm is a partner in a practice, and no other firm is held out as being a successor to the preceding practice. And finally, the practice that has assumed the liabilities of the preceding practice. So there's a lot in that. But again, the overarching idea is that you wind down your firm. We want to take your files. We want to cover you. We want to make sure that the clients that you were working for over the years, if they do have a claim against you for some reason, whatever, right, wrong, or indifferent, that it's covered. And that the new firm that's taking over your firm doesn't have the good stuff and not just the bad stuff. And that's essentially what this boils down to. For your run-off cover to continue and to be your obligation pre and post cessation, I think Keith touched on earlier on with regard to written notification, and do it so in an orderly manner and very quickly. But for us, for your fund, we require written notification 60 days prior to the end of your indemnity period. We need your last proposal form and policy document and your post-cessation contact details. Again, a question that was raised just a couple of moments ago. We always feel that the adherence to the close of practice guidelines is the best way to wind down a firm. And we also ensure that there are no claims or circumstances that might give rise to a claim that is not notified to your existing insurers. It's a very important requirement. When you're closing your firm and you're looking at your files, and if you're aware of any circumstance and or indeed claim that for some reason you just don't feel or have the confidence to report it in, that lack of confidence could cost you a significant amount of money in terms of a claim if you don't report it to your current insurer, because we cannot cover that claim when it goes into the fund. It's as simple as that. And I always feel that it's a horrible place to be when you have a claim as a practitioner. We speak to practitioners every day, and it is a very stressful time to have a claim made against you. So what we tend to do when you're closing your firm is, it's not for us to abdicate our responsibilities. Absolutely not. We just want you as a firm, as a principal, as a partner, to close down without any liabilities going into the future. Again, protecting your retirement. Because what you do is you carry your deductible and your responsibilities, unfortunately, until death. And unfortunately, that's just the way it is. Or the claims, and then the statute barred. But I mean, in reality, that's what you will carry in if you don't close down property. Post cessation, I suppose what we want is prompt notification of a claim. If you do get correspondence, we need you to cooperate with the conduct of our claims. Again, if circumstances change, we've had situations where a firm is closed, and all of a sudden it's reopened again. That firm cannot remain closed within the fund. That firm has to come back out, and the succeeding practice rule kicks in with the new firm. Again, fairness and equity in that. So someone doesn't close it for 6 months, and then all of a sudden we're going to take it back out because they didn't feel. And that's kind of, I suppose it is quite unusual, and people might feel, why would that happen? It has happened. And that's why, unfortunately, as an industry, we just have to make sure that protection for us as practitioners remains there. And I suppose what we always want to be do is kept up to date with your contact details, for obvious reasons, practical reasons. Your run-off cover is a different to your current indemnity cover. It is, and splitting it on both because I think it's important to have both up on the screen. Again, run-off cover, post-cessation, it's infinite for as long as the fund operates. There's no premium. Cover for finance institutions included, for compliant firms. You have a limit of indemnity of 1.5 million in the aggregate, not each and every claim. Very important consideration. Third-party claimants are entitled to notifying claims directly to us as the SPF manager, and you carry in the same excess as you did for the year you cease practice. It's very important. If you're carrying in your deductible in your 5,000, 10,000, you carry that in to your retirement. And I think, as a practical measure, for someone closing down, and do so, as Keith says, in an orderly manner, well in advance, look at your insurance requirements 1 to 2 to 3 years out. Look at your deductible 1 to 2 to 3 years out, because you are going to carry that in. So are you better off paying a higher premium coming in to the fund, reducing your excess or deductible, by virtue of the fact you won't carry that level into the fund when you retire? You don't want to have that hanging over you. That's a practical measure. Now, your insurance requirements may not allow you to do that, but it's something I would always try and give practitioners that advice to do so. You don't want to be carrying in a 5 grand, 10 grand, whatever excess it is, because you are responsible for that. You've finished practicing. You're meant to be enjoying your retirement. ARP cover then is slightly different because it's again only designed for current firms who are operating. So again, that's why there is a difference, and I wanted to make sure it's limited for 1 year. There's a premium. The claims by financial institutions are excluded. Now, in the current market, and I suppose it's coming up to the end of November, if you can't get cover on the open market as is, and you want to proceed into next year, and you can't get cover, you, of course, can come to us, and we will, of course, give you a quote. But understand, very one important aspect is the claims by finance institutions are excluded. And if you're doing any banking work, anything like that, you're restricting yourselves in terms of what type of work you can do, because with regard to service level agreements and so on, banks are very clear about what type of cover you have for you to do that type of work. Again, it's important, it's just a practical advice that I give in terms of firms who are coming in who can't get cover on the open market. The same limit of indemnity is in the aggregate again, and there's no automatic right of entitlement for third parties because you're currently participating. You have an insurance contract. That contract is with us and you, and no one else has a right against that. And then just the deductible and the prohibition on start-up firms. You can't just start up and go straight into ARP. You have to practice for a number of years, and you have to get cover in the open market, and then it's on the basis that you can't get the cover, we have to provide you with the cover. So that's a big slide. There's a lot in that. But again, it's important to note the differential between the two different types of cover. And we can touch on the questions at the end. Compliant and non-compliant firms. How this originated. When the fund was originally set up, what we found over the years, in 2011, there was about 120 firms who decided we're getting into this fund, it's free, we're getting out. And it was possibly, one of the biggest sea changes in terms of insurance requirements for the industry, I suppose, at that particular point in time. But what happened was, once that originated, we found that firms were not being compliant, and that was costing the industry a lot of money. People were not happy to discuss cases. They weren't prepared to give you their files. We were receiving claims. There was no conduct in terms of information, all those key aspects, witness statements and so on and so forth. And what we found was that the compliant firms for which the fund was set up were best in school. The non-compliant were costing the industry. And that has a knock-on effect to your insurance premium. We did an evaluation of the non-compliant firms and the cost to the industry for the period between 12 to 14. And the firms who were not compliant cost us approximately 86% of the overall incurred figure. And these are firms who this was not designed for, but unfortunately they got covered by virtue of the fact that this particular aspect wasn't boxed off at that time. So what we do now is we have a compliant and non-compliant designation, and that's set up only in recent and effective 1st of December 2017. And I suppose the easiest way for me to explain it is that if you don't comply and you have a claim from a financial institution, you won't be covered. Because those were the claims that were hurting the industry. Again, the issue regarding that was, and why did we pick on the banks? I suppose it was for the public protection. People don't really mind that the banks were getting particularly hurt on this. It's your ordinary client, your Joe Bloggs, your Mary Smith, or whatever the case may be, who had a missed statute. You've forgotten the statute, whatever the case may be. These things happen. And that's what this was designed to cover. Because what we have is that sometimes when a practice closes down through maybe suspension or for whatever reason, and they can't comply with their obligations post-claim, the ordinary public should not suffer because of that. But again, a different view is taken on the banks. So the current trends with regard to the special purpose, as you can see, when you finish up, what we find is that we get a lot of conveyancing matters, registration of title, things like that. You haven't boxed that off. I suppose carrying in your excess to do that type of work, if we could easily charge 3 to 4 or 5 grand in order to sort those particular matters out, but that comes off your excess, so we will be trying to recoup that. So again, it just gives you an idea of what possibly could happen when you come out of the fund and what those particular issues. And if you look at it on its very basis, it's conveyancing, and that's you have personal injury, maybe missed statutes, probate, and so on and so forth. But again, I can touch on those figures in later on if you so wish. But it's just to give you a kind of an absolute overview, and that's over 6 years evaluation. So clearly, it's the issue that you should be looking at if you're closing your practice down. Many firms, we roughly look at 27 firms a year in the industry close every year. We've one firm in the ARP most years. The chance of a claim being made against you is at its highest in the first year you come into the fund and reduces. And that's done through data analytics that we carried out. The risk presented to the special purpose fund is highest for those firms entering the fund due to being struck off or following suspension. I suppose the top 10 claims, we always like our top 10, by maximum potential loss is made up of 50% conveyancing, 30% commercial lit, and personal injury. That's us for now. I'm here to happy to field questions. My colleague is here also if you have any questions around the special purpose fund.
Can you explain why it would cost 3 to 4 to 5,000 to finish off a registration when the solicitors are doing the entire conveyancing for less than £1,000?
It's what happens is inevitably when a claim has been submitted, inevitably the client has engaged a new solicitor to write to us first and foremost. Then the investigation takes place as regards the claim. We go try and find the file. We then have to engage with the new plaintiff lawyer in terms of in terms of the whole issue. We may not get the claim file or the actual physical file for quite some time. There could be, we might have to engage our own firm to present various letters to compel the solicitor to hand us over the file. And by the time we end up re-registering everything, by looking after the plaintiff's fee, that's when the costs are incurred on a cumulative basis. So that's kind of, again, it's an arbitrary figure that I've literally spelled out, but that's kind of how it's made up. And I suppose what's most unfortunate about that aspect is that you've had your client, you may not have sorted out the issues because of, for whatever reason, and then that particular individual clearly is entitled to get his or her title registered. And I mean, I suppose and they have to go to a new firm, and that firm want their costs. They don't see this again, like the old days. They say they have a new client. You know, they have a new client instead of, you know, you might get the mum, the dad, whatever. And I suppose that day is gone. And I suppose the industry is very quick to fire off letters against colleagues now, where maybe historically it wasn't. And that's kind of, and that's, I'm not casting dispersions. I just think that's what happens. So by the time we come through the investigation, our own panel, the new lawyers, fees can be, and then obviously the work that's carried out in doing the work. And it seems very unfortunate that you end up getting costs again and haven't been able to do it yourself. So I suppose what I'm trying to explain is the more work you do, and again Keith and I think Simon touched on it, you can do to tidy up your loose ends. Yes, it's hard work, but I think it will save you in the long term in terms of your peace of mind and your pocket, basically.
Can I just check one thing?
Yeah.
You mentioned about the excess in the years coming up to
Yes.
retirement based on your current policy. Now, is that, like, our excess is for each and every claim?
Yes.
Now, is that the same when you come in, you know, that if you were carrying the excess, that excess into the ROF,
Mhm.
that it would be the same for each and every claim? Because you mentioned here that the aggregate here is 1.5 million.
Yes.
Whereas in our, it's for each, you know.
It'd be each and every claim, and then up until the aggregate. So you've only 1.5 million worth of cover.
Yeah, right.
But if you have claims individually coming in,
Yeah.
that would be applied individually. Yes, it is. And I suppose, again, a practical measure, like we work with every insurance company in Ireland and in the UK who participate in the market. And I suppose the prices are keen. They're keen to do business. You might think differently, but I mean, the premium pool over the past, I'd say since the crash has diminished massively, the premium pool has come down maybe 12 million in terms of where it was at. So in terms of what the industry has been charged. So I suppose it gives you an indication. But if I was closing a practice tomorrow, I would want the least amount of deductible going into the fund. And I suppose that's...
If a pattern developed where the year before everybody retires, that they don't have any, you know, that they say, well, I won't bother with the excess this year. I mean, that probably would prompt.
I mean, I suppose it might do, but at the end of the day, the rules are there, and it's designed.
Currently, you can do that. Right?
Yeah, and I mean, I suppose again, the whole overriding issue about the runoff fund is to protect the public and to protect solicitors' finish and give them peace of mind. And it's about an orderly wind down. It's about ongoing cooperation. And that's all it is, and then we're happy to cover. We make no restriction. If there's 1 or 1,000 in the fund, we don't really mind. We just want ongoing contact with going forward. That's all we ever want.
The good news is I'm not going to talk to you about anything to do with merging or selling your practice, but I am going to tell you about Law Care and what it provides to you as a member of the Law Society. So first of all, a big thank you to both Keith and to Shane for giving us the opportunity. It will be maximum 10 minutes, my talk. So if nothing else, remember not my name, but the name of Law Care. There are leaflets outside and little cards and top 10 tips for you to pick up. And we are, of course, available through the bespoke Irish website, lawcare.ie. So I was thinking of you as small practitioners, sole practitioners, and we do get a lot of calls from people like yourselves. And this image came into my mind. Does anyone know what it is? Please shout out. I know you're waiting for your coffee, but anybody know what it is? Sorry, say again?
Teddy bear with an ice cream.
Well, oh, I love it. It's not, but it nearly is. It's something called a weeble. Do you know what a weeble is? Ah, great, great. You see, I was born in the 50s, and it was one of my first toys. And it's called a weeble. And what's your name?
Tom Walsh.
Tom. So, Tom, would you please just give me that quality of the weeble? What is it again?
It can't be upended.
It can't, no, but you said it better before that. Yeah, well, I wish I had one. I tried to get one, but they're very hard to obtain. You knock them down, and what happens? They pop back up again. Now, they might stay down for a while, but they do pop back up again. And when you're a child, you think that's amazing. You know, you can knock your toy over and up it comes. But I like the idea, too, that it can be upended. And I do think, and I once was a solicitor, and I do know a bit about what goes on in the business of law. But if you think of yourselves, it can be a lonely place, but I think there's a great resilience in Ireland and in the UK too among the sole practitioner or the small practitioner. And maybe that's an image for you to take away. Think of yourself as a weeble. There's a lovely wee song on the internet. Anybody know it? Weebles wobble, but they don't fall down. Those of you who have grandchildren or children, have a look, because it's a great concept. So this was my image for you, but I like the idea it's a teddy bear with an ice cream inside himself. So Law Care is a charity. It's here to promote and support good mental health and well-being in the legal profession. We're 21 years old, nearly 22. We're funded by one of the 17 bodies, including the Law Society of Ireland. And we cover all branches of the legal profession, so that includes the bar and legal executives as well. The most important word on that slide is the word confidential. Whatever you come to us with remains confidential unless we think you're at risk to yourself, to someone else, or you're going to commit an illegal act. We are independent of the Law Society, so we don't go shopping people, we don't go talking to regulation about what we've heard, not at all. And of course, we're well up with the social media. So why would you want to ring us? Well, when I looked at Keith's slide, the two words that really hit me were doubt and uncertainty. I'll remember the word sigmoid curve. I have no idea what sigmoid means, but I did understand doubt and uncertainty. And when you are in business on your own account, or you're contemplating all the things that have already come up today, it can be an uncertain, difficult place. Not quite as uncertain and difficult as Brexit is, but nonetheless. And by the way, I do apologise for Brexit wholeheartedly. You can guess which side I voted for. But we're there, we're all lawyers, and we listen to you without judgment. We're there to listen with empathy. So try and understand a bit what you're experiencing, what all the questions, the doubts and uncertainties might be. We have 104 volunteers who have worked or are working still in the law. We have 6 here in Ireland, but you could get anyone. You could say, I'd really like to talk to a Scottish solicitor about closing my practice or whatever. And often indeed, particularly in Ireland, our callers will ask for someone who's outside the jurisdiction of Ireland because you all seem to know each other. We might signpost you to resources. And I'll talk a bit more in a slide later on about peer support, because I think that's where we could really give you some value and some help. We do have a welfare fund. It's small, but we often use it to help lawyers of whatever age and stage who might benefit from some counselling that we're willing to pay for, up to a threshold of €500. And we're open every day, including Christmas Day, but not 24/7. One of our biggest things is about signposting and giving you information. We'll never tell you what to do, but we might nudge you towards somewhere. There are fact sheets on all kinds of things: stress, depression, bereavement, all the big things that all of us in this room, we will go through at least one of those things at some point in our lives. The top 10 tips are easy to put inside your wallet or purse. You can sign up for Law Care News. There's something new on there every quarter. And we do case studies and blogs. I'm going to mention a blog. I was on the helpline a couple of Fridays ago, about 2 months ago. That's not a couple, it's more than a couple. But a man called Michael Williams called, and he said, "Oh, hello, Mary, you're the Irish coordinator." "Yes, I'm phoning from Ireland, but I don't need any help." And I thought, well, this is an odd call. And then he said, "That article you wrote, which I did, on imposter syndrome that came through the e-zine," he said, "it rang so many bells with me when I was a solicitor in practice. And if you look now on our website, he's written a blog for us. And if any of you in this room would like to do a blog about your life in the law, something that happened to you that you've worked through, just get in touch." But it's worth reading. Who calls us? Well, it's still the women who call us most, although it is starting to change. 65% female, 35% male. But the new statistic that is really very marked, more junior lawyers are ringing us now, up to 45%. When we say junior, we mean less than 5 years qualified. Oh, I don't know why it's doing that. The reasons for the calls: stress is at the heart of every single one, followed closely by depression. Not a word we use, but a word that the caller might use about themselves. And then it goes on. Bullying is on the rise, sadly. Disciplinary, not so many, 8%. I think it's because the legal workplace, any workplace these days, all our lives are 24/7. We don't seem to be able to get the 7 hours sleep because of the devices that we all have in our pockets. We are accessible, and clients do expect an instant response. These are the things that affect all of us, but you particularly in your workplace. Too much to do if you're practicing on your own account, trying to multitask, although the research shows increasingly you can only really do one thing at a time. They used to say that women could juggle everything. It's not true. The research is showing now that actually, although our brains are smaller than men's, we are not that different a thinker, which is interesting. We are perfectionists. I include myself. I once was in practice. Of course we're perfectionists. That's what our clients want to instruct us for, that we know the answer and that we'll get it right. Type A personality, ask Mr. Google about that. Definitely characteristics on there will mean a lot to you as lawyers. And long hours culture. You know, gone are the days. Were they ever really there when we work 9 to 5? Often we know that some of our callers are going in on the weekend. We know that people are working from home. We know that they have links back to work and they're taking it all home, and it's hard to switch off. You particularly, as small practitioners or sole practitioners, often you don't have someone or someone that you can trust to delegate the work to. And there is also the factor of loneliness. Angus Lyon, who wrote this book 3 years ago, he's one of our volunteers. He is a lawyer and he's a psychotherapist. He talks about us as very cerebral. What does that big word mean before your coffee? Cerebral means that we use our brains. I think it's true, because that's what we're doing. We're thinking for our clients. We're looking at all possible scenarios, and it's quite hard work. I think we do use our brains more than some people in other professions. And if that is the case, then the need to care for this thing called the mind and the brain becomes really important. The brain-world connection is the mind. Nature gives us a brain when we're born. What happens to us makes up our mind. And we know, I haven't got time to go into it in great detail, but we know that we can actually change our patterns of thought in a more positive way, that we can rewire the brain. That's all about the material substance of the brain. This is the thinking bit, the bit that I would hesitate to say, but sometimes I think we can overuse as lawyers. Thinking independently, finding humour, taking responsible risks, picking up on something earlier, listening with understanding and empathy. You do that all the time with your clients, trying to understand them. Just a minute. When you're in the thick of it, even after today, when you're thinking, well, what will I do? Will I merge? Will I sell? Oh, should I phone that man and ask him in detail about the ARP or whatever it is? Take a minute. Just a minute. It's a very short period of time. And really, even now, think, what am I thinking about? I hope she ends soon. I need my coffee. Or I really do need to make that train back to Limerick at 2:15. Yep. Just a minute. Just clock in with yourselves where you are. Mindfulness, a lot of us have been doing it before it became a fashion, before it became a buzzword. Give it a go. If you're a real cynic, go online and look at the app Headspace. It's free. It's a way of just pulling back. The old thing about, I know my mum used to say to me, if you're going to shout at somebody or tease them at school or whatever it is, count to 10. Mindfulness is about pulling back just a little. It's this thing about we as lawyers, we tend to work and live more in our heads rather than with our hearts, where the emotion and thought is. What am I thinking? What am I feeling? And what physical sensations am I aware of? If you even just take a minute, you might discover that you've got a sore shoulder from all that hunched over your desk, or that your shoes hurt and you haven't really noticed, because we don't notice enough. This is all in your handout, so I won't go through it. But I would say every day switch off, even for a minute. Or just go outside and walk for a minute or two. Give you a little idea of people who call us. Now, obviously, I do what I call mash the facts, so that you could never identify who this person is. So we'll call him James. That's his age bracket. He's working as a sole practitioner with just a part-time secretary, and a client complaint comes in, and then the client gets very abusive. He's been reported to the regulation department, and he's very worried that it might go to the SDT. He's behind with case files and he's missed a deadline. And then as we get to know him over the calls, we hear more about what's going on with his health. This is what we did at LawCare. We signposted him to a panel member. We gave him helpline support over several months. We told him in the beginning about our fact sheets. We mentioned to him about visiting the GP. I don't know what it is about lawyers, but a lot of them just don't seem to ever want to go near their doctor. We discussed the benefits of counselling or psychotherapy, but perhaps one of the most important things that we did was we buddied him up, palled him up with a peer supporter, somebody who had gone through a disciplinary matter and was through the other side and was okay again, if you like, had come through it. Different jurisdiction, though, as requested. And that was so valuable to that particular caller, to talk to someone who'd been through it and survived. Our peer supporters, we have 6 here in Ireland, but we have altogether 104 volunteers behind the scenes. And this is my favourite expression. I think what they do is give hope, an anchor of optimism. Someone who's been through a crisis in their life, a stress, a big stress, and is through the other side. They give encouragement, that wonderful quality of empathy, consistency, they're always the same. They give their time, free of charge, on the phone, their experience, and they've been handpicked, if you like. They are interviewed, references are taken up for their ability to connect, because life without relationships is nothing, really. And maybe they give something like that too, without knowing it. In counselling terms, it's called holding. It's not physical holding, but it's the idea that someone is really listening to you and really taking on what you say in a bid to try and help. Last thing about taking care of yourself. Again, this is now becoming an industry. It's quite interesting how the world is changing. But self-care for so long, I think, was self-neglect. Ideas to go away with: walking. All truly great thoughts are conceived while walking. Well, that's what the philosophers say, and I think it's true. Very hard to have an argument if you're out walking with someone, or if you're out walking on your own. It helps calm you down. It gives you a fresh perspective. Sleep. As Shakespeare said, knitting up the raveled sleeve of care. Mrs. Thatcher allegedly and Ronald Reagan could survive in 4 hours a night. Nonsense. Both of them ended up with Alzheimer's, as I recall. I think so. None of us can really survive and do our best for our clients, for our health, for our lives, for our families on 4 hours a night. It's a myth. We need at least 7. So have a look at your sleep pattern. Breathing. First thing you do when you're born, last thing you do when you expire. How's your breathing? You should breathe from here, not from here. That's when you get the squeaky, high-pitched note, when you're under stress and you're breathing from down here. Again, go and have a look at mindfulness. So those are the practical suggestions, but I guess I want to finish by saying, remember that we're there. We are a membership service. We are independent from the Law Society. We report to them on an anonymised statistical basis. No one is ever identified. So we're there for you, and if you want to talk through what's going on in your life or what your cares and concerns are around the whole idea of changing the course of your life through merging, selling, retiring, not dying. We can't really cope with that, I don't think. You would be very welcome to give us a call, and either you'll speak to one of us or we will pal you up with a peer supporter. Thank you very much indeed.
Good afternoon. So my name is Barry McCarthy. As I say, I'm a tax advisor with Hayden Chartered Accountants. We're based in Amiens Street, and one of our areas of speciality is dealing with legal practices. So what I want to cover with you today is the potential tax implications of selling a practice. Particularly it's capital gains tax, and that's the predominant tax that would affect the seller. I'll just briefly mention stamp duty, but that's an issue for the purchaser. There's capital acquisitions tax, which is really only if you're selling it on, if you're passing it on at undervalue to somebody. And every other speaker so far has mentioned something about debt today, so I thought I'd put in CAT as well. There's the VAT implications of transferring assets. There's income tax, and then there's existing staff and PY, PRSI, and are they being transferred to a new business. So just as a kind of an overview of capital gains tax, the predominant issue when you're selling a practice is, are you selling the goodwill of a practice, and if so, the goodwill will be liable to capital gains tax. There is a thing about whether, as it was spoke about earlier, and I think is one that we spoke about later, is about how do you value goodwill, or can you get goodwill out of a practice in today's market. If it is goodwill, though, the current capital gains tax rate is 33%. That is high by international standards, and it used to be 20%, but probably going back further, it was 40% in Ireland. But 33% is a potentially high tax rate, but is still less than income tax, which could be up to 55%. So, kind of as a very general thing, a seller will normally want it to be treated for capital gains tax purposes, and a purchaser would rather it to be treated for income tax purposes. So there's always a conflict there between what the purchaser wants and what the seller wants. Capital gains is a tax based on a gain in a sale, which is the sales proceeds minus the cost of sales minus the allowable costs give you your capital gain. The sales proceeds, it's the proceeds for the capital value of a practice. So it's not about the work in progress value. It's not about transferring debtors, which, as you were saying earlier, you mightn't transfer anyway. But it's about the capital value of the practice, the goodwill you've built up from your client database, the potential for further work from those clients and the referrals. If you're transferring to a related party, if a son or daughter is taking over the practice, market value is substituted for the actual sales proceeds in any CGT computation. The next point is probably the most important one, is deferred consideration is taxed immediately unless it's not possible to value. So even though you might sell a practice and the goodwill hasn't been valued yet, and we'll say that we will give you a goodwill value in a year's time or 2 years' time if certain conditions are met. Depending on how that is worded, if it could lead to a capital gains tax liability. It is not a consultancy agreement, which is different. A consultancy agreement is where you continue to work on the practice and help them afterwards on future work. So there's a difference there. Just because the consideration isn't paid up front does not mean that it's not capital gains tax. So the example there is that John agrees to sell his practice for 200,000 with 100,000 payable immediately and a further 100,000 payable after 1 year. For CGT purposes, the full 200,000 is included in your initial CGT computation. There is no discount you can't, no matter how far, 5 years, 10 years, there is no discount you can apply for time value of money or any other discount. It's the full proceeds that you're entitled to get under the contract. Where you have a situation where it's not possible to value the goodwill will be a situation where you might say, I'm selling a practice now for €100,000 and I'm going to get 15% or future fees out of a client bank. Then you can't possibly value that at today's date, so you can't make up a valuation. However, if they put some sort of a maximum value, say you're going to get 15% of the future income from these clients subject to a maximum of €100,000, then CGT again would say the €100,000 is the value you should use. If it turns out later you don't get €100,000, you can go back and redo your tax computation. If you get more, you'll obviously have to do an amended tax return. As I was saying, capital gains tax treatment does not apply to work in progress. And this is always a key thing when you go selling a practice, is that you prepare a set of completion accounts. And in these completion accounts will be your value of your work in progress. Again, as a general rule, the purchaser might like the work in progress to be as high, whereas the seller might want to keep the work in progress low, because when it goes in as work in progress, you are subject to income tax on that work in progress immediately. So it's always a matter to be discussed, and the value, and there is those accounting standards and the UITF 40, I think it is, which kind of gives you guidance about valuing it. There's also specific sections in the Taxes Act, Section 90, which covers the valuation of work in progress in professional practices. But where it's work in progress and it goes into your completion accounts, that goes into your income tax return and is payable in that year. The purchaser gets the work in progress and they get that at a tax deduction when they get the final fee comes in. So the purchaser obviously likes that because it reduces their future income tax liability. When you look at the allowable costs on capital gains tax, most of you probably know this already from your own practice of selling properties and different things with clients. But it's the cost incurred on the sale of a practice, the original cost of acquiring a practice, cost of acquiring other practices during the lifetime, and to note that indexation relief still does apply for costs that were incurred prior to 2004. After 2004, there's no more indexation, and indexation cannot be used to create or increase a loss. So, as an accountant, I always like to have a figures example. So, Mary started her legal practice in 1990. In 1994, she acquired another practice for €100,000, and she is now selling the entire practice for €250,000. So the computation of that is you have a sales proceeds of €250,000. There is no initial cost because it was set up originally. There's a cost of acquiring a new practice of €100,000. There is indexation factor because it was before 2004, and that gives you a gain on disposal and a potential liability, CGT liability, of €40,000. So even though that's less than an income tax liability would be, you can see it is still a significant tax cost that needs to be planned for. There are some ways, hopefully, that can be reduced further. The first one is the annual exemption of €1,270, which is pretty meaningless, but it is €1,270 of a gain. It's not a tax credit. So it is basically just get rid of any sort of small disposals. One that's coming up a lot now is unused CGT losses carried forward from prior years, which can also include CGT losses from a spouse where you're jointly assessed. I've had this now a lot in the last couple of weeks when we were doing the income tax returns, that people started making capital gains again, something that was not done for about 10 or 15 years. Nobody heard of capital gains tax. You bought something and you lost money, and that was the way things went. Now people are selling stuff and making money on capital gains. And I've had clients come to me who have never mentioned it before, but I've said, here's the CGT liability on this gain. And they've said, by the way, 7 years ago I invested in a property in Shanghai, never told you about it. I lost €70,000, can I use that? And yes, you can. If you had bank shares and you made losses on those, you can use them, or any shares. So it's not just trading or any trading capitals, it's any capital losses in the past that you have not used are carried forward indefinitely and can be used. And as I say, it can be surprising that clients who you think you know very well always try to hide the losses and say, I didn't get involved in that scheme. I was thinking about it, but I didn't bother. Or I only put in €10,000. I didn't buy the Bitcoin thing. All these things happened, and now they're coming up with kind of a smile on their face again, saying, actually, I put €100,000 into it. I put family savings into it, and now I have a big loss. Can we do anything with it? So it is very important that you look at the CGT loss history and see if they're available. The other two big reliefs that are there are retirement relief and entrepreneur relief. Both of these, in the case of retirement relief, could potentially reduce your tax bill to 0, and entrepreneur relief can potentially reduce your tax bill to 10%. Retirement relief, the big issue is there's no requirement to retire. So the name is just confusing, but there's no requirement to retire from this practice and the other practice. So it was said in other earlier talks about potential options, and one is maybe to wind down or to concentrate in a certain area and maybe get rid of other work. You could potentially sell the other work, claim retirement relief, and continue on in the exact same practice in a specialised area that you wanted. If you're also maybe winding down with some clients that you want to keep on, but want to sell the vast majority of your client bank, again, that is possible under retirement relief. There's no requirement to sell everything. You can sell a certain number of the client database and continue on to retire. Claim the relief. The main criteria that do apply to retirement relief is you have to be over 55 years of age. You have to have owned the assets for a minimum of 10 years. The one thing I just want to note on the owning the asset for 10 years can be in a partnership situation where a partner has joined or left the firm and your percentage shareholding has changed. So you might join the firm with 3 partners. So you're all entitled to 1/3. I don't know, you can vary that in the partnership agreement, but as a simple example, if you're all entitled to 1/3. If then one partner retires, the remaining partners get 50% each of the future profits. The 10-year test may not be applied to the full 50%, because if the one partner only retired 5 or 6 years ago, that 10-year requirement would not be held for the entire 50%. In that case, you would be entitled to retirement relief for your 33% to 1/3 share you always had, but you may not be entitled to retirement relief for the additional amount to bring you up to 50%. What qualifies for retirement relief is any qualifying business asset. So we talked previously that goodwill is the thing that we're always talking about in valuing a practice. But also, if you own the property that the practice is trading from, that is a chargeable business asset and it qualifies for business relief, provided it is owned for at least 10 years. So it was mentioned before about whether or not you should sell the property or not. It probably depends if you qualify for retirement relief and what the gain is on that property. If you do not sell the property and start to rent it out, it no longer qualifies for retirement relief because it is no longer a trading business asset, it is an investment property. So if there is a gain on the property, even if there's no goodwill in the practice, but there's a gain on the property and that could potentially be sold, then retirement relief may be available in that case. What retirement relief gives is a full exemption from CGT on qualifying disposals. So it's entirely tax-free. There is a lifetime threshold of €750,000, but this is reduced to €500,000 for individuals over 66 years of age. Yeah, and that's the thing about it. This mightn't be a problem. The issue, unfortunately, it's not a problem maybe for your goodwill calculation, but where it may be a consideration is if you have, again, a property, a commercial property, and maybe if you're in Dublin or something, but if you're close to the €750,000 on that property, and you wait till after you're 66, then you exceed the threshold, and potentially the full amount becomes taxable. Now, there is marginal relief, which means that your tax liability will never exceed 40% of the excess. So in the case of €750,000, if you sold something for €850,000, the threshold is exceeded by €100,000. It means your CGT liability cannot exceed 40% of €100,000. So your maximum CGT liability will be limited to €40,000. There is no threshold for transfers to children where the disposer is aged 55 and 66, but there is a $3 million threshold after 66. That's probably even less of a problem than the 750,000 and the 500,000 thresholds. But again, it can be important if you're transferring to a son or daughter a practice with a property involved. The property has to be used in the course of the business, so investment properties wouldn't qualify to be transferred with the business. The other relief is entrepreneur relief. This mainly applies for if you're too young for retirement relief or your threshold, or you're going to exceed the threshold. It's officially known as the revised entrepreneur relief because there was an original entrepreneur relief introduced, which basically never applied. It was a case of if you sold an asset, made a gain, got involved in another business, sold that business would get some 50% relief on the CGT payable, which basically nobody was going to qualify for in any short period of time. So they replaced it with a revised entrepreneur relief. The revised entrepreneur relief applies a reduced capital gains tax rate of 10% on the disposal of qualifying assets. Qualifying assets are, again, business assets. You must have held the asset for at least 3 of the 5 years, and it applies to a threshold of €1 million. In this case, it's not a lifetime threshold, or it's not a excess, or only the excess is taxed. So the threshold of 1 million applies over your life, but only the amounts above 1 million get taxed at 33%. The first €1 million is at 10%. Again, this could apply to a property used in a business. And as I said, typically entrepreneur relief would apply where the retirement relief thresholds have been exceeded, or the age requirements, or owning the asset for 10 years hasn't been complied with. To kind of finalising the CGT, just on a summary of the key dates, again, you might know these already, but disposals between January and November have a payment date of the 15th of December. So it's just important to be aware that if you have a capital gain in November, you have a very short payment period to actually pay it. Potentially, you have only 15 days to pay it. And as we talked about earlier, you could be paying tax on deferred consideration. So you could be paying tax on money you haven't received, which can cause cash flow problems. If you dispose of it in December, you have the payment date of the 31st of January. So obviously from a cash flow point of view, sales in January, February, March of the year give you more time to try and plan for any liability. And the CGT return is required to be filed by 31st of October in the following year.
Sorry, can I just ask you in relation to a purchaser? A purchaser, is it correct that they just want to avoid paying a capital sum for the business because they can't write it off unless they subsequently sell it 10 or 15 years later?
Yeah, I would say they probably have, to be nice to them, they probably have commercial motives as well, or they might honestly believe that there is no goodwill. But yes, there is always this thing of, like, as a general rule, the purchaser will want it to be income, and the seller will want it to be capital. That's always kind of been the rule. There's personal circumstances that might change the situations, but if somebody pays for goodwill, they get no tax deduction for it. Whereas if they pay for work in progress, they get a tax deduction. I'll just briefly go through stamp duty. You know that as well. That's another reason maybe why a purchaser might not want to buy capital items, is they have to pay stamp duty on the acquisition of a capital if there's a document to transfer. If you're transferring assets as a part of a business, there is a transfer of a business relief. So if you transfer an asset from one accountable person to another, it's outside the scope of VAT. It's not exempt from VAT, it's not liable to a 0% VAT rate, it's outside the scope of VAT. That doesn't mean that you can reclaim VAT on professional fees associated with that work. This again becomes even, or from your own practice experience you might notice, this can become complicated if you are transferring a property, because you have to look at the VAT history of the property, and also transfer of a business relief rules. I'm not sure if you're involved in that, but Revenue had guidance about what properties they consider to be qualify under transfer of business relief. And they had a number of worked examples, and everything was working along in that way, nice, and everyone's kind of happy and getting used to the new VAT rules. And then in the end of July, start of August of this year, Revenue produced new guidance which changed their opinion significantly on what properties they think qualify for transfer of business. So that now, whereas the old rules, Revenue said, well, we think nearly every property comes within this rules. If you have a lease, if it is rented, if it was rented, all those they thought was transfer of business. In the new guidance says, in most of those cases, there won't be a transfer of business unless there's a lease in place, an existing lease, and there's different things to make it more of a business. So VAT and transfer for the normal business should be straightforward enough, but if you're looking at VAT on transfer of a property, that will take a bit of consideration to go back through the history of the property. And again, if the property has been bought in different stages or there's different partners, it can be hard to get that information together. But there's potential VAT issues of a clawback or that you have to jointly opt to tax it, or that it is liable to VAT. Capital acquisition tax, I'm not going to go into in too much detail, but if you're transferring a practice to a relative for less than a market value, CAT may apply to a beneficiary. Again, you might say that the goodwill won't really apply because you could argue there is no goodwill in certain practices. But again, if the premises is being transferred as part of that, then there could be a CAT potential. And there are reliefs that are available there. The most important one there would be business relief, which you can reduce the market value of the property for the son or daughter when they're looking at their threshold. This only applies if you're transferring it to them at less than a market value. If you're selling it to your son or daughter, obviously that wouldn't apply. Income tax. In the year of cessation, income tax is based on the profit from the 1st of January to the date of cessation. So it's just a change of rules of how you apply it. So if you do accounts every year to March and you cease in April, your final year tax bill will be based on your profit from the 1st of January to the 30th of April, or the date you cease, regardless of when your year end is. So your normal year end could be March, it could be September, but the cessation rule says it's the 1st of January to the date of cessation. And there's a bit of a look back that needs to be done to make sure there's no underpayment. I am not going to go into that in too much detail, but it's something to worth considering when you're looking at it, if there was a large fee income coming into the practice at certain times, just to make sure you're not double taxing it through this look back. It's an easy calculation to do, but sometimes there can be a timing issue on an income tax because you have to look back to the previous year. If you're doing the accounts up to the 31st of December every year, that won't matter. But if you're doing them on any other time, it's important that you speak to the accountant and look at this look back provision and say, am I better off waiting for a month before I cease? And this was mentioned previously, I think, on the regulatory thing as well, but from an income tax point of view, if there are two partners in a practice and one retires, both partners are ceasing in the partnership. So cessation rules will apply to both partners. And the partner who is continuing on the practice is now a sole trader, and they start off under income tax commencement rules again. So the remaining partner cannot just continue on doing what we're doing and saying doing accounts the 30th of September every year, and we'll just continue doing that. That can't happen if it's moving from a partnership to a sole trader. If there's 3 or 4 partners in the partnership and one leaves, the partnership continues on, and that doesn't affect the partners. It's only where you're going from 2 partners down to 1. It can't be a partnership with only 1 partner. It's back to a sole trade. If you look at merging as well, that's also the case where if you're a sole trader and you bring somebody else in as a partner, you are ceasing a sole trade and you're moving into a partnership. So there will be income tax cessation rules on the sole trade, and there will be commencement rules on the partnership. Finally, just briefly, I want to mention about transferring employees. If you are selling your practice, it's what happens to the existing employees. If staff are retiring or ceasing employment, there's a potential for ex gratia termination payments. These are not redundancy payments, so you don't have to satisfy the requirements for redundancy. These can be paid to any staff member. So if there is a family member who's working in the business, they potentially can get ex gratia termination payment. And this termination payment is tax deductible for the practice. There's 3 formulas to work out what the max, and you can claim whichever one is the most beneficial. But it's basically about €10,000 plus 600 and something euro for every year of service. I'll probably pronounce the next thing wrong, but it's TUPE regulations, or TUPE regulations. I'm not going to go into these in too much detail in front of solicitors, because I'm sure you all know them a lot better than I do, but it's just to be aware that employees transferring over, and that there are rules and regulations that need to be applied when you're transferring staff over, and that they do retain their benefits and transfer over their entitlements. If you are merging a practice or bringing a new one in, the employees have to be ceased under the old employer number and commenced under a new employment number. So there's a whole revenue guidance about how you do this under a transfer of an undertaking, and about issuing P45s and setting them up on a new system. The one thing I suppose that should make our life easier is PAYE modernisation. You're probably all sick of hearing about PAYE modernisation now, but from the 1st of January 2019, PAYE is moving to this online system where P45s, P35s, P60s, all those returns are gone. They're not going to apply anymore. So if an employee starts with you, they give you their number and you give that to revenue. You do not need their P45, and it won't exist anymore. At the end of the year, you won't give them a P60, You will for 2018, but from 2019 onwards, you won't give them a P60. Revenue will give them a statement showing what their income was for the year. And at the end of the year, you do not have to do a P35 because revenue have the information already. So on something like transferring employees from one practice to another, the PY modernisation system should make this a lot more efficient. And that's pretty much everything for me. Is there any questions or? Yeah.
Could it bring you back to the slide on the VAT? I think it said sale to an accountable person.
Yeah.
What if it's say an assistant solicitor in some other firm who wouldn't be VAT registered?
They have to be VAT. In order for the transfer of business relief to apply, they have to be VAT transfer. They have to be registered. If it wasn't, then you'd have to look at what's being transferred. But more than likely, you would have to charge them VAT, and because they're not VAT registered, they wouldn't be able to reclaim it.
Would they get VAT registered in advance for that purpose?
Yeah. Well, not for that purpose, sorry. But again, the VAT registration threshold is 37,500 a year. So I would think it's probably in practice is very few solicitor firms who are buying another practice that aren't expecting to have a turnover of over 37,500 euro. So I haven't come across that in the practice where some practice is not VAT registered and wants to become VAT registered just for this purpose. If they're buying a practice or if there's somebody who's setting up for the first time and buying a practice, they expect their sales to be above 37,500, so will VAT register. So theoretically, it could end up that transfer of business relief wouldn't apply, but in practice, I haven't come across that. Okay. Anything else?
Can I just ask you about the premises? You mentioned that if your business premises is not sold at the time, you will lose retirement relief. So that means that if you sold your practice but didn't sell it, you kept on the premises and rented that maybe to somebody who bought your practice, would you lose then the retirement relief?
You'd lose the you'd lose the retirement relief, and it is kind of strictly applied by revenue. Because it doesn't apply in this case, but if you were having a limited company and you cease trading, revenue allow you to liquidate a company within 12 months and claim it. But you have to liquidate it in 12 months, and you have to take steps to immediately, if you start renting out the property, it no longer is a chargeable business asset. And it's something that's rigidly applied by revenue. And the concessions they do are, again, rigidly monitored to make sure that it doesn't turn into an investment property.
If you sell your business first,
yeah. So again, that goes back to there's no requirement to retire. So you can keep part of your practice, you can keep 95% of your practice if it's very valuable, and 5% gives you 750,000. You can basically, the retirement relief part is just a complete misnomer. There is no regulation, there is nothing about retirement in it whatsoever. So if you sell to a practice and they say, I want you to stay on for 2 years on a consultancy agreement to help smooth the transition, you can still claim retirement relief in that case. Not on the consultancy income, but on the capital of selling the practice. Okay. Thank you.
Next up, I'd like to welcome James Cahill.
Thank you very much for inviting me to give this short presentation. I'm from the west of Ireland and practices haven't been too easy to sell down there. I was heartened to see that only 27 or thereabout firms close annually. The title of my short discussion is Some Practical Thoughts on Winding Down a Practice or Preparing it for Takeover, because I suppose for many of us, we don't actually know 2 years in advance whether we'll find someone to take over the practice or whether we'll have to close it down. Though I think that position will probably improve for reasons that I'll come to shortly. The key points really, the succeeding solicitor, staff and the management, file distribution and cash flow management. Topics which I would not cover in the presentation obviously are those topics that have been covered here already today. Advanced notification to the Law Society, in order to secure the best terms available on PII runoff cover, reporting, accounting, closing reports, and such matters which are set out in great detail by the Regulation Department. With regard to staff, I believe the solicitors should assist staff in gaining new employment. And many years ago, before the advent of the transfer of undertakings, I had friends that were retired, they're long dead now, but had a business with 114 employees. And they were so proud of the fact, a husband and wife team, they were so proud of the fact that they actually got employment for every one of the 114 people. So in the same way, I do believe on a practical level, solicitors who will in small offices, in any size office, who will have had a close relationship with staff over the years should set out to try and ensure that they can be placed in other offices in the event of them not being able to find a succeeding solicitor or a succeeding solicitor's practice coming in that doesn't need all the staff who have been employed in the office which is closing. However, a note on the transfer of undertakings obligations. Passing on the business in any form is what it refers to. So, passing on the business in any form comes within the meaning of a transfer of undertakings. And the obligations per a decision made by the Workplace Relations Commission, formerly when it was the EAT. The example I have is the case of a shopkeeper who had a few members of staff, secured alternative employment for the members of staff, closed the business and leased the premises to another shopkeeper who set up the same drapery type business that the former owner had. One member of staff came back and said, well, actually they had an entitlement under the transfer of undertakings, and the EAT agreed they had their entitlement. So simply moving the staff from one job to another did not fully deal with the issue, and I believe this represents a certain risk for any sole trader, and including solicitors. I suppose during the closing down period, a solicitor will be receiving very little income. Cash flow in the office will reduce and ultimately disappear, while certain overheads will continue. To ease this, solicitors should embark on a structured plan not less than 2 years before retirement, I believe. And I think there was a reference to 3 years already here as maybe certainly a time to begin to think positively about this issue. That plan will involve consideration of what files can be destroyed, handed out to clients, and those to be retained. I think it's wise to write to clients explaining the need to comply with requirements in GDPR, if not covered in the retainer agreement, comply with basic good housekeeping, not to be holding on to old files, and I think, frankly, to free up storage space. We should encourage clients to collect their files if they decide, their old files, if they decide not to collect those files, they may be destroyed. Now, in this regard, I really think that solicitors have been behind the curve somewhat in that we, as an occupational group, we have spent our lives preparing contracts for others. And we have never, or we've been very slow to prepare contracts for the relationship between ourselves and our clients. Really, people feel that the sort of compliance of Section 68, which has got to do with fees, is all that's required to be done. When you actually think through it, we really need to have contracts, actual contracts with our clients. Because when you think of all the rules and regulations being imposed on solicitors, and what we've heard here today, they basically arise out of a situation where the solicitor and client relationship is based on an open contract. So that, for example, very simple thing, a contractual relationship with a client could set out that files will be destroyed after, say, 6 years, that the option would remain with the solicitor, that is completed files, of course, that the copyright in all of the work done is held by the solicitor. There's no reason why the solicitor cannot own the file. The common law position, as I see it, is that the client owns the file, and of course the client owns the file, unless the solicitor has entered into a contract to the contrary. If you took that very simple point, it would hugely simplify the getting out process. And I don't see the getting out process just a matter for the solicitor who's retiring. The solicitor who's retiring must think in terms of the next generation of solicitors who have their own dreams and their own lives to lead and want to set up in business and want to be in business. And I'll just refer here to a report which everyone is going to receive very shortly from the Law Society. It's the Crowe-Howarth study into small practices. And it really is a very positive and wonderful report. And I suppose coming from the west of Ireland, I know of a number of practices that have been up for sale for many years and they couldn't get buyers, though one has recently got a buyer to come in. The wonderful thing is that I saw in the report that 25% of solicitors who responded to the surveys have set up in business in the last 5 years. So it's quite clear, and despite huge numbers of solicitors from certain areas going into work in large firms, that there's a yen out there among all the younger people to be in business on their own, just as the same as it was for us X number of years ago. It's still there. It is up to us as practitioners to see how we can set out to facilitate those people who haven't set up on their own, who won't be able to set up on their own, but would like to set up on their own by buying into our practices. And it is for us, therefore, to set out to reduce the responsibilities and risks and burdens which those next generation solicitors will be taking on. Also, with regard to this issue of clients taking up old files, I have a particular example. An old school pal of mine got into inner health, a terminal illness, and I agreed to assist in the winding down of the practice. And there was full cooperation from the society, and I came across it in circumstances where it was realised that the poor unfortunate solicitor had a mounting number of complaints coming in about the solicitor because they couldn't do anything in the first instance, and naturally the clients had no idea what to do, and it's up to some practising solicitors to step up to the plate and go and help out their colleagues as best they could. This involved the removal of over 2,500 files, data, accounts, the cooperation with the Law Society accountant to come in and try and help up in situations, communication with the banks. I actually found them to be all very cooperative. In particular at the time, one of the big banks, I suggested to their staff, will you come down to my office? Let's go through all of the undertakings with that particular bank and because these were solicitors and they were coming into the office, and go through the files on a practical level and decide what they could take out of it. And in most cases, the basic work had been done. Yes, there was bells and whistles. Yes, there is not necessarily a certificate of title passing, but I never heard anything from those banks again. So it's not all a matter of fearfulness and fear of the future. There are many, many positives. The other issue is the disposal of wills, of course, but that's a very easy matter to deal with, I feel. Again, the object of the exercise, to my mind, should be to reduce the risks for the solicitor who will either take over the practice or takes over and becomes a succeeding practice. Particular ongoing and with particular ongoing files of the practice. I think that by reducing the risk in managing the removal of old files, old stock really, unwanted stock which is unwanted, and the taking over of the remaining files will be a much less daunting exercise for the new solicitor. It is usual, as was referred to already here today, for negligence actions to commence against solicitors not more than 2 years after the solicitor has retired. I think the reality is, and it was touched here already, that very few actions commence against retired solicitors following 1 year after the retirement. And therefore, the risks may, on certain levels, for a practical sensible solicitor, may not be as big as we can be frightened into believing they are. I think that properly run down, the solicitor can retire in the knowledge that they are, that they are properly catered for under the new run-off cover arrangements. Every retiring solicitor should do his or her best to establish another solicitor as a succeeding solicitor, if it's further, because for the remaining files, because naturally, no matter what the retiring solicitor does, there are going to be there's continual work to be done in the office, and it's a matter of a smooth transition from one generation to the next. I think it is important that the solicitor guarantees to assist the succeeding solicitor, succeeding practice, if a new solicitor doesn't come in to take over the practice, with inquiries, nuances that might arise on a file, again, for a period of at least 2 years after retirement. Very simple, very sensible. That will be of huge practical assistance and comfort to the incoming solicitor. And anyway, under the insurance run-off regulations, the retiring solicitor is in any event required to cooperate and assist with the run-off fund. So it's probably much easier on many levels to cooperate with whatever solicitor is taking over, in whatever form that solicitor is taking over. When you think of it, this is no different from what is expected from a solicitor who in practice is defending a negligence action against himself. Any solicitor who's had a negligence action against them knows they've had to do an enormous amount of work themselves anyway to defend them. It's not like an insurance situation where someone else does it all. The solicitor as a defendant had the files and you had the knowledge, and the defence side relies hugely on the solicitor who's been sued. The principles are the very same, really. An example of a solicitor who introduced clients to a new solicitor prior to retirement. I came across a case where a solicitor, admittedly with a small office, actually discussed the issue of retirement with each of his current clients, and went and visited one of the younger solicitors in the town with each client and arranged them to take over. Well, that was very much appreciated by the new solicitor. They were going to get a file, they knew there was no skeleton in the cupboard, and they were also introduced and met the client of the retiring solicitor. Certainly in many small towns, most small towns through the country, that is a practical proposition. Maybe not for every client, but for a certain proportion. The solicitor signed retainer agreements should incorporate a policy with regard to closure and destruction and ownership of files. I've touched on this already, and I really think that if solicitors are, it's never too late to begin a process, and I would think this is a process which everyone in the country should commence upon in a practical, sensible way. I've used a retainer agreement since 1994. It has become much more sophisticated in recent years, unfortunately, and longer, just because of the nature of change in practice and obligations in particular. But nevertheless, it contains a clause whereby we may issue an updated version of it. So in that case, if I do issue an updated version, I can send it to clients, and it is the new terms of the office with regard to those clients. I think once upon a time there was perceived value in thousands of old files, but they are now a burden and a liability that the next generation does not want and cannot afford to have. Now they are a burden and the next generation does not want such files, and in particular, they don't want closed sales. I mean, they don't want personal injury files that have been completed years ago. They don't want miscellaneous court files that are just adding to paper and backlogs, or not backlogs, but log jams, and taking up valuable space in an office and inevitably cost money. They are stock on the shelves, I describe them as, that cannot be sold. They're no good to anyone in this day and age. Therefore, the retiring solicitor should trim down and slim down the amount of paper they have in their office. while there are other files involving trusts, etc., the majority of property purchases can be filleted out. If there are valuable documents for clients, just send them out to them. Solicitors in the last solicitors have become much more attuned to risk management and reducing the risk in our practices over the past 10 years. And I think this again has been alluded to already by the continued reduction in negligence actions being taken against solicitors. This overall concern about risk is far more in a far more complex practice environment is also known and understood by younger colleagues, some of whom look forward to being in business on their own. The law school are stressing and have been stressing for years to trainee solicitors the need to manage risk. And I think the law school has probably been stressing this to trainee solicitors much longer than the mature solicitors, which the older solicitors have been cottoned on to in the last 10 years or so. The solicitors considering retirement ought to consider matters from the would-be succeeding solicitor's perspective, whether that succeeding solicitor is in an established practice or considering a takeover of the practice of the retiring solicitor. Generally speaking, traditional general practice is not as profitable as it was, say, 30 years ago, and the obligations carried by the solicitor are far greater. I was surprised to see that 23% of solicitors, that was the figure, yes, in the Crowe-Howard report, study on sole practitioners and smaller legal practices in Ireland recently, which will be disseminated by the Law Society very, very shortly to all offices in the country, that 23% of the responding practices have been established within 5 years. This is proof of the appetite which solicitors have and continue to have to be self-employed and run their own firms. Their own practices. Rural practitioners are aware of the huge number of newly qualified solicitors remaining in the large cities. We should be mindful, however, that the younger generation of solicitor taking over practice will want to know that the office they are about to enter into has been well run, its technology is up to date and managed, and the business location is right. And so many older solicitors are in towns throughout this country in excellent locations. And these locations were valuable and will continue to be valuable in any line of trade, shop or legal practice. The huge benefits still exist. And new good locations, of course, arise where towns have been enlarged, etc. And that's mainly so, of course, east of the Shannon. Offering previous accountants' reports and recent Law Society inspection reports by the retiring solicitor to an incoming solicitor would be very beneficial, to be open and clear about these. They can begin to work in the office in the knowledge that there are no skeletons and unfinished files which could result in nasty surprises for them at a future date, with all the consequential effects both in the use of their time and their future PII premiums. So again, correctly introduced, there is a high value for a solicitor to buy into an established practice as against starting from scratch in a clean office. We all know, and as I said, the Crowe-Howard report shows the appetite for people to set up a practice on their own. However, I think certainly those who set up a practice many years ago don't have to think too far to realise that they have actually built up a huge potential. It's to manage that potential sensibly and practically that's involved. So I have an example of a solicitor who was offered and did not take up an established practice about 30 years ago, and who later set up on his own and regretted it. In essence, the reason came down to nervousness and insecurity on the part of the younger solicitor. And I've spoken to the solicitor, and that's what they told me. That's really what it came down to. The economy wasn't great, etc., etc., etc. But the solicitor was off the practice and the house going with the practice at the time, and always regretted not taking it up. Didn't really realise about the value of all the wills that might be in a safe, etc., of course. In that respect, the retiring solicitor leave the office clean as it were, for the next generation. But in that case, the new solicitor will continue to build on a lifetime of experience and refinement in the office and have the benefit of existing infrastructure. It takes a lifetime. A tradesman spends a lifetime putting tools together. It takes solicitors a lifetime to put the infrastructure into the office. And really, the incoming solicitors, there's tremendous value for them out there. But it is up to us, it is up to the older solicitors to present it properly and get assistance where necessary to present it properly. Again, as solicitors in particular, we know all transactions are based on contract. However, when it comes to dealing with our own clients, solicitors have been way behind the curve for the last 25 years in not entering into contractual arrangements with their clients. Again, I've touched on this and I'm going to close on this because I believe this is so hugely important. Solicitors should avoid being in an open contract situation with their clients. Being in such a contract, the law imposes many different obligations on the shoulders of solicitors, which by contrast could be varied, so that, for example, in the retainer agreement, solicitors can retain copyright, as I've already referred to. They can retain ownership of the paper files, and in short, they can retain ownership of the work product. And these records could be valuable. In such circumstances, the solicitor has a far greater discretion to destroy old files, to retain them, as the case may be. Solicitors can protect themselves in many other ways. With this in mind, I have consistently used retainer agreement in my office since 1994, rather than just a signed retainer agreement, rather than just the Section 68 letter. But in the last 15 years in particular, that retainer agreement has become much more comprehensive, and I have used it as a risk strategy reduction. As traditional loyalty from clients, quite frankly, and sometimes can have unreasonable attitudes taken by an increasing number of clients in recent times, has, to my mind, made the use of the signed retainer agreement with the client almost an imperative. Should any solicitor wish to contact me, my email address is info@jamescahill.com. I will be happy to email my own retainer to them as a Word document, and I would hope that he or she would come back to me with comments and observations, because these documents are living documents, really, and they change as the times change. I hope I haven't spoken too long, and if anyone has any questions, please put them to me and I'll do my best to answer them. Thank you. Can I just say, one point that I forgot about momentarily, though I did touch on it, was the issue of getting maybe outside assistance in looking at matters in advance of retirement. Because the reality is, if we have some outside assistance, we can get a better perspective. We do need to buy into other people's experience. I think that is also a very practical and sensible step to take. Thank you.
Thanks very much, James. And last but not least, we have David Rowe.
That's okay. Good afternoon, everybody. Okay, we're running late. We're going to be zippy here, get you through it. Okay, so I want to talk to you about trends in buying, selling and merging practices. So the value of practices has fallen in the last 10 years. The old rules of once turnover is long gone. Barry gave a very good presentation on the tax implications, but sadly for those as buyers, and I think one person in the audience picked it up, there aren't huge goodwill values in the market at the moment. So the previous rules of thumb that are listed there don't really apply. Perhaps the last one does. you're selling your work in progress if you're getting out, or you're buying work in progress if you're getting in, plus potentially a negotiated goodwill payment. So the market, where the market is now, the market, to pick up what James said earlier on, the market is certainly much better than it was 3 or 4 years ago. There are far more buyers, there are far more sellers. There were always the sellers. So there's far more buyers now, and there's a reasonable equilibrium in most parts of the country between buyers and sellers. Having your practice neat, tidy, your reputation as a practitioner, and all of those things feed into whether you've an attractive proposition to sell. There's lots of buyers, and to again corroborate something James said earlier on, there's a town not far from James where somebody has recently bought a practice that was for sale for a long time. There's another practice where the guy decided, I'm going to start my own. I know there's 2 out of 4 of the practices for sale in this town, but when I look at them, they're not attractive for me. The guy has started on his own and is actually doing very, very well. So it'll be interesting to track the lady that decided to buy the existing practice versus the guy that started on his own. And my prediction, having met them both, is they'll both do very well. I'm not even sure which one will be the winner if we want to look in those terms. So, so buyers, what do the buyers expect to pay? They expect to pay you 30 to 60% of your annual fee income, or twice profits, or the most realistic way of looking at buying a practice at the moment is you pay for the work in progress plus a small goodwill payment. That's if you can sell it. And my biggest issue, I do lots of, I'd say I do 5 of these a month, where I'm either acting for the buyer, acting for the seller, or I'm a broker in the middle and telling them both to get independent advice. My biggest issue is usually persuading the seller that the market where it was at once goodwill is no longer there. And they're telling me endlessly how many wills they have and the value in the practice and the value of the connections. And I'm saying that's all fine and absolutely valid. But the market is not paying those type of values at the moment. And again, pick up something James said earlier on, younger buyers are nervous. They're not looking at taking on a whole pile of liabilities. And it's interesting, a lot of startups in the last number of years, we do a practice advisory thing, which is subsidised by the Law Society with them. And, people 5 years ago basically set up practices because they were let go. People in the last year are setting up practices because they see it as an opportunity. It's completely different now. So if you have a good firm, you can sell it, and there are plenty of buyers around. So when are you going to get goodwill? Barry talked very well earlier on about the tax implication. So what do you need to do when will your practice have a goodwill value? There's no point talking to you about how you value it. It's a matter of negotiation. It's a matter of looking at all the moving parts. Here's some of the things you need to have in place. Good PI record. That nearly is a prerequisite whether you're going to get goodwill or not. You're not going to sell your files, or you're not going to sell for work in progress value if you don't if you're not known. Every practitioner in their locality is known as a good or a messy practitioner. If a messy practitioner comes to me, somebody that has a reputation of not being neat and tidy, comes to me to sell their practice, I say, basically I don't take them on, because every place I go with that I'll get the answer back, well, I wouldn't be so sure about that. I'm not going to have PI issues coming forward on that practice. So we need to have a good PI record. If our fee income is steady, that's good. And look, people understand the recession. They understand it's recovered, and they understand the ups and downs. It's better to have a wide spread of clients rather than a high dependency on 1 or 2. If we've a repeat type practice, that's good. If we've strong probate, that's good. And if we can show somebody that the practice, it's live, I'm still taking in new instructions. Another one of my nightmare instructions is sell the practice for me, David. But I'm telling you now, I haven't really been taking in new work for the last 3 months, and I look at the person and say, "What have you got to sell?" You've got to keep the thing live and vibrant until you move it on. In some cases, so the value, I'm saying to you, the value is really the work in progress plus potentially something for goodwill. Sometimes you won't get goodwill at all, or you won't even get fully paid for your work in progress. There are things that are kind of seen as negative would be lumpy or inconsistent fee income. If the practice is very personal, the view taken there is that, and certainly most sole owner practices are very personal. The view taken there would be that once the sole owner goes, the practice will dissipate. And there's plenty of towns where you try and sell a practice, and all the other practitioners in the town say, I'm not going to buy that, actually, because I know that there's only 4 or 5 others in the town. We all stand off this. None of us buy it. I don't think they talk about this in a coffee shop, but maybe they do. And we'll all get 20% of it free of charge. So that does happen. So if the practice is very personal, and it's hard to get away from that if you're a sole owner, if we've got PI issues, if we don't have repeat income, and if our pricing is an issue. So the pricing can be either overpricing or underpricing. So if we've been underpricing consistently, the buyer will take the view that this person has spoiled their clients. I'm never going to get the pricing up in this portfolio of work. If we've been overpricing, the view will be taken that, okay, the client was prepared to pay high prices to that person because they gave them very personal service, but once the practice transfers, it's very much into an open market competing with other practices. And obviously your service levels are really important too. Aidan Leonard, didn't hear him, but he's fantastic, so I'm sure he dealt really well with PI. I'm not going to say anything on it, except that most practices now sell on a succeeding practice basis, 19 out of 20, okay? So most buyers can get their head around the latent risk in the files, okay? Doesn't actually really matter to the vendor what basis you sell it on. You'll get slightly better value if you can sell it on a succeeding practice basis. Okay, so what type of practices are selling well? If we've good conveyancing, good probate, good wills cabinet, good spread of clients, good work in the pipeline, continuity of fee income. Staff, I find, is one of the biggest issues in terms of selling a practice. Staff liabilities. So I have a whole pile of staff, I'm 65, and I have a whole pile of staff that have been with me 30 years, and they mirror my own age, and there's no retirement date anymore. That's a big issue. It's very hard to convince a 30-year-old solicitor that he or she should take on this liability. Ways around it, there are ways around it. The practical way around it is that you pay up their statutory redundancy entitlement to date, and then the clock starts at 0 again in terms of years of service. But even that one can be a struggle. And of course, staff are an asset, and of course they have links into your clients, and of course it'll help in the retaining of business. But length of service and numbers of staff is an issue. A practice will sell well if, as a vendor, you're prepared to do a period of time after you sell your practice. And that can be as little as, I'm doing a deal at the moment, the vendor wants 3 years. Purchaser completely happy with that. But it has to be a minimum of maybe 3 to 6 months. So if you want to get out and you never want to see the place again, on the Monday after you get out, that's a problem for the buyer. James has gone into this earlier on. So I think niche specialist areas are attractive, and if we've good systems and good IT, that's attractive as well. If you're a buyer, and it looks like quite a lot of sellers in the room today, and I'm assuming all the buyers are online. No, I tell you what, I've worked it out. There's an equal number of buyers online because they're employed maybe by some of you in the room, and they can't come out and disclose themselves. So hello to all of them. If you're a buyer and you're looking at buying a practice, here's my advice to you: get a breakdown of the turnover, the fee income by work type and by client. Understand where the work is coming from. I think a brilliant exercise if you're a buyer is to just go through the invoices in the last year. Just flick through them. It's amazing what you learn from that. See where the firm is invoiced and what rates they're invoicing at. In doing your financial assessment, factor in a salary for you as partner, factor in a rent, because often people own their own premises, and premises can be a big enough factor in terms of buying, selling or merging. Assume a 20% fall in the fee income. That's probably about ballpark in a reasonably successful migration. You may be able to save something on overheads, but overheads in the law firm are reasonably fixed. And then see, are you going to make money on it after that? I do think it's a fantastic time to buy. It's not a brilliant time to sell, but it's better than it was, and there are buyers out there. So how do you find practices for sale? It's hard to find attractive firms, or it's hard to find good buyers. So the first one, of course, I'd say this is us. We do a huge amount of matching. We have buyers, we have sellers, and we put them together in all parts of the country. I'm doing one in Galway at the moment. I've just completed one in Bundoran, where there is only one practice. I'm lots in Dublin at the moment. I'm doing one in Sligo at the moment. So all over the country. Generally, there are buyers and sellers, and certainly, I know James would have covered this earlier, west of the Shannon, there are definitely more buyers now than there were 3 to 5 years ago. I'm not going to pretend there's a plethora of them, there's not, and some areas of the Midlands are quite difficult as well. So we have buyers and we have sellers. The Law Society of Buy, Sell, Merge, that's good as well. You will get there are serial responders to Buy, Sell, Merge they're serial responders who aren't serious. They're tire kickers. So just be careful on that. I see those responses coming in. I do think it's a good way, and you will get some names that you may have not have got otherwise, but you do get a lot of responses generally, and you can probably eliminate 8 out of 10 out of them. So I think it's good, but I think you need to be not relying on that solely. You can advertise, that sounds horrendous, but you advertise it under something like our cover, and you don't do it under your own cover. I think a good way is, and James touched on this earlier as well, you approach somebody directly. You see somebody in a neighbouring town, you see somebody who is, you think might want to return to your area, you approach them either directly or through somebody like us. Gazette is good, and you respond to adverts. Those are where you find them. If you're looking to buy a practice, here's what you need to do. Get an advisor on board. Source the firm that you're looking to buy. Check it out informally. I'm saying it's a small market. Every firm has a reputation, good, bad or indifferent. It's very easy in Ireland, we're a small community, to suss out whether you're potentially going to be taking over a firm that's been well run or hasn't been. You will have experience with people opposite them on transactions. Assess the practice that you're looking at, negotiate, do your due diligence. There's 2 types of due diligence, file and finance. Close the deal and then integrate the practices. And I could do slides in each of those, but time doesn't permit. So, danger signs if you're thinking of buying. High dependence on the firm that you're thinking of buying has high dependence on one client or one source. Sloppy and unfinished work, bad reputation. Never. My advice to a buyer is never ever take that on. It'll break your heart trying to fix that. You'll spend huge amount of your time trying to fix it, and it's just not financially, it's not worth it. Another one that is a danger sign if I'm acting for a buyer is people that are accelerating their billing or window dressing. So let me tell you about that. So accelerating your billing is billing too early, and window dressing is, and I do understand that. Window dressing is when we have a fantastic last year just before we come to sell it, and some of you are. I know we're in the law side today, but the regulation department is at least, it's out of earshot, but some of you will have fees maybe that you've been stacking up for a while and haven't transferred, so the last year looks particularly good. I think that's all fine, but be honest about it. Say to the would-be buyer, I've brought forward fees that maybe I should have transferred in previous years. So, if you've done it, fine, but just be honest and declare that you've done it. Fees charged under or over market rate are a sign we've gone through. Competition from current staff. If you're a seller and you have somebody in your own place that might be interested, you're almost obligated to offer to them first. Because if I was a buyer, if I'm advising a buyer and you're the seller and you've got a person that would potentially like ownership in your firm, and we're going to bypass them to sell because you think you might get a higher value from an outside buyer, I'm going to say to the buyer, look, that person breaks away, they'll probably take 30, 40, 50% of the practice with them. and we're really not buying it as it appears. So if you're a seller and you have an internal solicitor, you're even if you think the answer is going to be no, I think you're obligated to go there first. And James talked about you having a moral obligation, and I'd agree with that as well. The age profile of the clients is wrong as well. But look, I think clients of all ages are good, obviously. All our clients are within 10 years plus or minus of our own age. As we age, our clients age with us. They stop doing things. But, there's obviously things happen at the end of our lives that generate fees for solicitors as well. So, so the market... There's a good market for smaller private client firms. Legal firms are a good buy. The price is low. There are buyers out there. They're cautious. Neat and tidy is good. If we can, buying a practice at the moment, 170,000 fee income, costs 70,000 to run, 100,000 in profit for the buyer. Going to pay 30 to 40 in goodwill for that, share the work in progress on the files with the buyer, with the seller. I'm acting for the buyer, not the seller here. We're going to employ the seller for 2 or 3 years, because the seller wants to he doesn't want to go from working 5 days a week to doing nothing. He wants a 2 or 3 day a week thing, and he wants it to work for the buyer, because his name is on the practice, and the practice is going to have joint names on it. So there's a pride there. Most sellers have a serious pride in the business that they've built. They want it to go to good hands, and they're quite happy to work on it. Now, I think for a seller, that's slightly an odd feeling. You're working for somebody else in your practice, and you have to kind of accept that. And they're going to do things differently. They're going to have a different approach, and maybe you don't agree with something they've done. But honestly, it's, I had a lovely one in this practice I'm buying at the moment, where the seller came in yesterday and said, do you know what, in front of the buyer, he said, I'm going to give you 2 pieces of advice. First one is you need to make X the office manager, okay? So, because she's a star. And the second piece of advice I'm going to give you is you need to give X 5 grand more in salary. And I say to him, well, Johnny, let's call him Johnny. So really what you're saying is this woman is fantastic. You haven't looked after her for the last 10 years that you've had her. You've paid her below market rate, but you're now saying to this guy, you make up for what I didn't do for the last 10 years. Anyway, it's an interesting one. So his advice, he said I was very direct when I said that to him, so I couldn't disagree with him. But well thought out and well packaged firms are attractive. It's tough to sell, but there is a market, and the biggest thing is that the seller is realistic. Okay, if you're in a firm, you're looking at internal succession planning, so you've got somebody in there, you're trying to groom them for a partnership and taking over from you in time. What works is that you think about it. Somebody spoke about 2 or 3 year horizon. I think that is whether you're doing this internally or you're doing an external sell. You communicate with them, you invest in them, you give them access to things like fee information for the practice in maybe the 2 years. They become a salary partner perhaps, so that they can see and share in the challenges of getting work in, getting work across the line, good months, bad months, cash crises. I think you have to begin to involve people in that, and you have to give them time and encouragement. It doesn't work if you're trying to bring somebody through internally. If you say, look, I'm off in 2 months and it's yours, they will say, well, sure, I haven't really had any preparation time for this. So you should have made them a salary partner, in my view, for the 2 years previously. You've got to put some time into it. I do think as well, I find with firms that they look at Johnny or Jenny down the road in another firm, and they think that they're perfection. And they have somebody in their own firm and they overlook them. Well, the chances are, if you knew Johnny or Jenny in the other firm equally as well as you knew your own internal person, your own internal person may be equally strong, but we're all a little bit attracted to shiny and new, and you don't actually know that external person as well. We also have, obviously, people internally that don't want ownership, and I think you just have to respect that. And, if you've offered it to somebody, they've declined it, they're happy to stay as an employee, provided they're treated reasonably fairly by somebody coming in, they may well be happy to stay there. Would-be partners within your own firms or successors are concerned about the following. Can profitability sustain a new person? Will they earn more? In my experience, somebody coming through internally is happy to earn the same for a year or two. I don't think and they understand, if it's explained properly by somebody like us to them, that they've to invest capital in the business. The retiring partner has to get their capital out, and they're going to have to replace their retiring partner's capital with their own capital. So if their take-home pay is the same for a year or two, generally they live with that, if the rest of the proposition is right. Younger people are much more concerned about firms that they see as over-borrowed. And some of them don't want any borrowings at all. And then I sit down and say to them, look, if you're going to have 20 grand in recoverable outlays from clients, it's perfectly okay to borrow that. So that can need some explanation. But there is more aversion to borrowings in the younger generation because they look at the generation ahead of them and say they borrowed far too much, they got involved in property transactions they shouldn't have done, etc., etc. So there is an aversion there to borrowings, even to a manageable level of overdraft. They're interested in capital and what they have to put in. They're interested in the intentions of the senior partners. What they don't want is that you just go and they're left with the practice. They want some kind of migration period where you'll sit alongside them and support them, and you'll work with them to make it work. And whether they will take it over or not, it often depends on their self-confidence and how equipped they feel to take it over. It's not necessarily on the proposition that you're selling. And if you're looking at people internally, you can develop people over the years coming up to partnership to make sure that they do feel like they can win business, they can own a business, they can run a business, they can make correct decisions. But if you don't involve them in it and just say one sunny day, look, this is all yours, the chances are they will feel ill-equipped to take that on. What you want as a seller? You want a fair price. Usually people want to work on in some reduced capacity. I think even if you don't, you've got to probably give 3 to 6 months. If you do, 2 to 3 years is probably negotiable with a buyer depending on the volume of work. Of course, the seller wants as much of the work front-loaded, much of the money front-loaded as possible. So if we're selling a practice for a small goodwill value, which is probably what's around at the moment, and the rest is on the work in progress, there's very few buyers that can actually buy out your work in progress up front. So a lot of it is, so the quality of your buyer becomes important because you're relying on that person to be financially stable enough to pay you off as the files come home, which is the usual arrangement. You may get some, if I'm acting for the seller, we usually look for some down payment on work in progress. But, in selling a law firm at the moment, nobody has really the entire of to buy out your fixtures and fittings, to pay something for goodwill and to buy out all your work in progress. So you are dependent on the quality of your buyer being high. And if they make a mess of the practice, it does actually rebound on the seller. So we're looking for a reputable buyer. And most sellers want finality. So once they pass it over, they're saying, look, the market isn't great, the values aren't high, don't be asking me for indemnities. You do your own due diligence. Make sure that you're happy to take this on a succeeding practice basis. I'm not going to give you an indemnity. If there's something in the closet that comes through, that's your risk. You're getting all the good bits of the practice as well, and you're getting it at a fairly reduced price because the market isn't that strong. Okay, so market at the moment is good. Values not high, but there has been an improvement in values over the last 2 or 3 years. Banks are prepared to finance. They're if you're a buyer, you've got to present cash flows properly. I'm doing another transaction for somebody, and the bank has asked for 3 years cash flows. That's not unnormal now. So the banks will, if you can convince a bank, they're trying to lend, and they will lend to something that's properly presented. I think buying or selling typically takes 3 to 6 months. I think one of the big things for sellers is confidentiality. So how do I protect confidentiality? This is the worst time of the year to protect confidentiality, because what happens is I'm acting for you, a seller, we've spoken to 3 or 4 potential buyers.
they've signed, I would get people as standard to sign confidentiality and non-disclosure agreement. They've done all that. They've decided that your practice is not for them, and they will respect the confidentiality probably for the time that you're speaking to them, maybe a month afterwards. Then they're at a Christmas party and somebody says, did you see Bernadette recently? And oh, I thought she was selling. Sure, I heard she'd retired. So it is difficult. So therefore, we've got to get on with the process reasonably quickly and try to see it through. And whether, that's obviously wrong that people leak that out, but it is difficult. When people are engaged in it themselves, they respect the confidentiality. When they've closed the door on it mentally, they don't, in some cases. So your sale options may be local practices. Most practices are sellable onto a local practice because the overheads don't transfer at the same rate. So if you have an existing practice and you have another practice, and I go to the existing practice, and the existing practice is prepared to buy, it's the place that will make the most money out of that previous practice because they already have some of the fixed costs and the overhead in place. You can look at solicitors looking to expand into your area, or you can look at somebody being employed by somebody else that might want to take it on. I do agree with that. You should be looking at this 2 to 3 years out. But if you want to sell and you have a strong practice, generally they can be sold reasonably quickly. Final topic, won't keep you long. Merging. Why would you merge? You'd merge to widen the range of services offered, to become stronger in what you do. There's a lot of firms in Dublin at the moment looking at merging, maybe two six solicitor firms, saying if we could become a 12, then we're serious contenders for different types of work that we're seen to be too small for at the moment. You will get some cost efficiencies. They'll be 10 to 15%. You can some firms in towns merge to take out competition. If you had 3 and now there's only 2, the town isn't as competitive in that particular town. And some firms merge just to be defensive and to survive and to remain profitable. Bad reasons to merge. The first one is really, if you have a row internally, okay, and I get this all the time, right? People say, look, we're not getting on, but actually if we merge with somebody else, wouldn't it be great? That's not going to work. You've got to sort your row out, or at least have a truce in your row. The row will only transfer into the new firm. So in itself, if you're not getting on as partners, it's not a brilliant reason to merge. Just to get bigger for itself isn't a great idea. To fill vacant space, to follow a trend, or to deal with underperforming partners. They're not great motivations behind a merger. Mergers work well if they're a result of a plan, not a reaction. Various stages there in merging, which most people look at mergers when they get this, it's like being asked on a date, they get this approach from somebody else. And they get all starry-eyed and said, jeepers, that would be a great idea. Isn't it wonderful that somebody's actually asking us to merge? They haven't thought about it before. That isn't actually the way. You've got to go and look at your own firm first and say, are there reasons why we would merge? What firm would we like to merge? What type of firm? Not firm. You don't put a name on it. Where are we weak? Where are we strong? Why is our ideal merger candidate a litigation firm? Is it a institutional firm? Because we can't get to institutional work as we are because we're seen as a plaintiff firm. So you've got to, go through your motivations and I go through all the steps. And just because of the time, I'm going to skip through that. But there is a process in merging that I think you have to go through. If you're merging, we do it. Buy, sell, merge, do it. You'll know people yourselves who you rate or you don't rate. You'll hear it from clients. You'll hear it from other professionals. You'll see it in directories. Likely timetable. I've all the steps there. I'm saying it's 4 to 12 months for proper integration. We look at your firm. We look to see what might suit you. We match. We broker. We put the deal together, and we integrate it. And I think that generally works best. But then, if we're doing that, each firm has to get its own separate advice and do its own due diligence. That's the way it works. So if you're looking to merge, it's best, I think, to have an honest broker in the middle like us, and then each firm takes its own advice. Because if you have 2 sets of accountants sitting in a room, you'll never merge. There'll always be reasons why not. And some of that is the accountants don't quite understand the legal market as strong. No, Barry's okay with this, aren't you? Yeah. And then you go to Barry and you go to Hayden's for advice and say, look, here's what's been put to us. Is this fair or is this not fair? In good mergers, two firms aren't the same. You know, quite often I sit down with practitioners and they say, I want to merge, and I say, who do you want to merge with? And the people that they suggest are mirror images of themselves. That generally is not the, you know, and I understand there's a comfort factor in that, but it probably isn't the right thing to do. You don't have to be equally profitable, but you need to be reasonably similarly profitable. It's more about the energy, organisation, appetite for work and all that. So if you have two lazy practitioners in one firm, two lazy practitioners in another firm, that'll merge fine. But if you have two lazy practitioners in one firm and two work all the hours God sends in another firm, that won't work. Okay, so cost savings in themselves are not a great reason, not good enough reason to merge. You must have matching ambition, and over a process merging, it should become obvious whether this is the right person or not. Deal breakers in merging: incompatible personalities, professional indemnity insurance issues, badly run files. That we're very used to being a sole decision maker, and we won't adapt to the joint responsibility and joint decision maker mindset. Taking too much money out, we've taken too much money out, and we've doubts over trust. So those are deal breakers in terms of merging. Issues that can be overcome: name, location, different levels of profitability, staff, poor financial management can be corrected, and systems technology. And the rewards, if you merge and get it right, should be improved profitability. You share the management responsibility amongst more people. You have a wider skill set. You have a broader client base. You share the ownership, and you've renewed energy and enthusiasm. And good mergers work well. But you need to think it through, do your due diligence. The 1 in 30 that doesn't work probably gets a lot more press than the 29 out of 30 that do work. So, I'm just finished. Conclusions: good market, active market. There is some value there's really good value for buyers at the moment. There's some value for sellers, but you have to be realistic. You need to take somebody on board, as James said, to help you with this. You know, one of my least favourite assignments is somebody's tried 3 or 4 times themselves. They've had a bit of an alienation in relationships, either with the firm on the other side, with a would-be buyer, or with an internal buyer, and I'm trying to correct some of the mistrust stuff that's come. Mergers market is quite quiet at the moment. It's interesting. I think people are very consumed with running their own firms, and you know, probably in most parts of the country, the pressure point has moved from getting work in to getting the work out and having the staff to do it within a reasonable day. So if I go to somebody with a merger at the moment, they're saying, "Jeepers, David, I'd love to, but you know, come back to me when the next recession is on, and I might have time and space to look at it." So, okay, so there's our contact detail. Thank you very much. Questions? Anybody can come up to me. Business cards are on the table if anybody would like to contact me privately. Thank you. Thank you, Keith, for the invitation. Shane.